Petition dismiss.
Lordship, one pattern meter was listed before Lordship on Friday, but it could not be, it did not reach Lordship because of paucity of time. The petitioner is going to retire in January. Can it be listed, Lordship, either this week or Lordship in the first week of January, Lordship?
Okay, first week of January.
Item number 53, my lord.
50?
53, my lord. The matter is to stay vacated, my lord. It is from in the order column, my lord. My lord, it may be taken along with the item number 51 is stay vacated column, my lord. Add 2.
Okay.
Yes, my lord. Obligation.
Lily is the number 4 to be spoken to. Take up after some time.
Okay.
On motion item number 5.
None appears for the petitioner on call is the matter after 1 week.
Item 6.
Item number 6, after some time, I am filing the affidavit. After some time, may be taken up.
Supplementary list item number 44 and 45.
None appears for the petitioner on call is the matter after vacation.
46.
Same order.
Item number 47.
Same order.
48.
48, same order.
Item 50.
49 too.
Your Honor, time being the matter.
Time being?
Yes.
Okay.
Item number 7.
May it please, your lordship. Please, an impleadment petition, lordship. Direction was issued by this honorable High Court only, lordship. Lordship, last page itself, lordship. That is the order, lordship, of 10/11/2025. The director, education department had received, secondary education has received a copy from the higher authorities, that is the commissioner. She was to do the needful, lordship, but she is keeping it pending, lordship. That is the reason honorable court directed that she may be also made a party, lordship.
In the contempt proceeding.
Lordship,
In the contempt proceeding.
lordship, in the contempt proceeding itself.
Heard Mr. Bhagavate, learned counsel for the petitioner, and Mr. Sharma for you appearing for?
Notice have to go. For impleading, lordship. Respond number 4, lordship.
No, that
Notice have
provide whether the other parties are not supposed
Lordship,
to appear.
Other parties will be for 1, 2, and 3. It is up to them, lordship. For 1, they have appeared.
Okay.
Same order, lordship, but for 4, notice have to
Okay,
go.
this interlocutory application is preferred by the applicant. In contempt case number 556 of 2020. within bracket Sri Punyaram Boisya versus Pritam Saikia, IS and another. Under section 26 MC within bracket CR, Miss Case Civil Rule of Appendix 33 of Guwahati High Court Rule 2015 for implement of the new contempt or namely
MS Momata Hosai.
Ms. Momata Hosai. Momata Hosai. The learned counsel for the petitioner, Mr. Bhagawati, learned counsel for the applicant submits that in the contempt proceeding by the order dated 10/11/2025, this court was pleased to direct him to file to implead the director secondary education as a party respondent, and accordingly, this present application is preferred for implement of implement of Ms. Momata Hosai, Director of Secondary Education, as respondent number 4. Para. Taking note of the submission of Mr. Bhagawati, learned counsel for the applicant, and also considering the facts and circumstances on the record and the order dated 10/11/2025, this interlocutory application stands allowed. Ms. Momata Hosai, Director of Secondary Education, Assam, Kailipara, be impleaded as respondent number 4. Respondent number 4. In view of the order passed in this interlocutory application, the petitioner shall file amended cause title of contempt case number 056 of 2020 within a period of 1 week from today. List the matter after vacation.
Much obliged.
My lord, I am sorry, my lord, the 46 item profile I could not reach at the time when the matter was called.
We'll call it after some time, not now.
My lord.
Lordship, item number 45 and 46. Lordship, I'm sorry, Lordship.
We have already given the date.
Lordship, after some time, then.
No.
Lordship, kindly, Lordship,
Next item.
Lordship, kindly, Lordship, today is fixed for consideration of interim order, Lordship.
8 to 12.
After some time, Lordship.
I think 8 to 12. We file our additional. Then this gonna come after vacation for disposal because will certainly take time.
Who is for the petitioner here?
Petitioner, there are several petitioners. This page was leading the case.
None appears for the petitioner on cause. How about Mr. Kosik, learned dissenting counsel for the respondent in elementary education department present? Mr. Kosik submits that person to direction issued by this court. Person to the order passed by this court. The respondent in elementary education departments have filed additional affidavit. And as such, he pressed for listening the matter after the vacation. They are allowed recess and list the matter after vacation.
Grateful.
I'm sorry, Lordship, my 2 items maybe kindly be called for after some time, Lordship. Item 45 and 46, Lordship. 44 and 45, Lordship.
13.
Item 13. Here we have filed the affidavit on the last occasion. Lordship had said to file an affidavit. It is on record. And they had filed it prior.
But the petitioner is absent. None appears for the petitioner on call. However, Mr. Pukon, learned standing counsel for the respondent in elementary education department present. Mr. Pukon submits that pursuant to order of this court, the respondents in elementary education department have filed their additional affidavit, and the petitioner also filed reply. Since the petitioner remain absent today, remain unrepresented today, let's list the matter immediately after reopening of the vacation.
Item 14.
May I please, your lordship? Well, as per the schedule, lordship, they have made lordship, hearing has already been taken place and petitioner appear on 9/12.
9/12.
9/12/2025, lordship, a hearing was held. And they have to, lordship, produce the outcome of that hearing.
Who is appearing for secondary education department?
Secondary.
Secondary education department? Let it be on Friday or in the first week of January,
Friday, lordship.
Friday.
Friday.
Heard Mr. Khan, learned counsel for the petitioner. None appears for the respondent in secondary education department.
Hearing is outcome to place করব hearing কইছি আর তুই মানে রেজাল্ট তো প্লেস করব
If you think so.
Friday.
Friday. We'll take it soon.
You are appearing?
Yes, sir. Record back.
Mr. Kosik, later on, Mr. Kosik, learned standing counsel for the respondent in secondary education department, appear. Mr. Khan submits that on 9/12/2025, a hearing was conducted by the Director of Secondary Education,
No, by the secretary, lordship.
by the Secretary of School Education Department,
Department of School Education.
Department of School Education, but the outcome is not made available to the petitioner. Mr. Kosik, learned standing counsel for the respondent in secondary education department, submits that he may be granted some time to obtain instruction in this regard. Pair allowed recess the matter on Friday.
19.
Friday.
May it please your lordship?
Timing item number 4.
May it please your lordship, I really apologize for disturbing your lordship. Lordship, regard to item number 8 to 12, lordship has already passed the matter after vacation, your lordship. Lordship, kindly our appearance may be recorded, your lordship. In item number 8,
Later
9,
on,
your
Mr.
lordship. 9. DJ
Mr.
Das, your lordship.
So and so, learned counsel entered appearance.
In item 9.
Item 4.
Mr. Solia, is this office notice of dated 30/9/2024?
2024. This is the view of the ARTP lordship on the basis of which lordship sees our affidavit. Pursuant to this, we gave our views, lordship, page 100, lordship. That is dated 14/11/2024, where we gave the reference of this letter, Lordship.
এখানে ঢুকে গেল, এখানে ঢুকে যাবে।
Okay. Heard Mr. D. Borda, learned counsel for the petitioner, Mr. Soliha, learned standing counsel for the finance department, Mr. Sharma for elementary education department. Person to order dated 8/12/2025, Mr. Soliha had for his one office note dated 30/9/2024. Argument concluded. Judgment reserved.
Item number 15 and 16.
Lordship, this matter relates to selection for the post of principal, National HS College, School, Lordship. Now, Lordship, the advertisement was of 21/6/2016, Lordship. Subsequently, one Ratnadatta filed a petition before this court challenging the selection process, Lordship. Now, Lordship, in that petition, Lordship, there was a direction passed. Lordship, that direction, Lordship, will find at page 17, it starts, Lordship.
Page 17.
Lordship. Lordship, the relevant portion is at page 23. Paragraph 18. In the present case also, the issue relating to the appointment of a regular principal in the National HS School Lamding pursuant to the advertisement dated 21/6/2016, for which interview was held on 14/12/2016, is pending before the State Selection Board for its consideration, and the respondents in the Secondary Education Department is yet to take a decision in that regard. And further, the representations of the petitioner filed before the respondent authority are yet to be disposed of.
You are, Mr. Sharma, you are reading page number?
Page 23, Lordship.
Paragraph number?
Paragraph number 18, Lordship.
Yes.
In the present case also, the issue relating to the appointment of regular principal in the said National HS School Lamding pursuant to the advertisement dated 21/6/2016, for which interview was held on 14/12/2016, is pending before the State Selection Board for its consideration, and the respondents in the Secondary Education Department is yet to take a decision in that regard. And further, the representations of the petitioner filed before the respondent authority are yet to be disposed of. Taking note of this, Lordship, at the next page, Lordship, paragraph 21, it starts at page 23 only. Considering the above, it is observed that the concerned State Selection Board and the government in the Secondary Education Department, that is the official respondents herein, shall comply with the provisions of the relevant provisions of the Assam Secondary Education Professionalization Service Rule 2003 as amended, and the Office Memorandum of the State Government in the Secondary Education Department dated 6/6/2014, as well as the order of the Director of Secondary Education Assam dated 23/6/2016 in proper perspective as noted above, before finalizing the selection to the post of principal in National Higher Secondary School Lamding in pursuance of the advertisement dated 21/6/2016. After this, Lordship, I participated in that selection process, Lordship, along with that Ratnadatta, who was petitioner in that petition, Lordship. This was the direction passed. Subsequently, a speaking order came to be passed. Lordship will find that page 25, it starts, Lordship. The third paragraph, Lordship, at page 25, Lordship.
Yes.
On examination of the panel list prepared by the School Selection Committee and forwarded by the Inspector of Schools, Nagaon, it is seen that there are 4 candidates in the panel. That is Sri Shankar Ranjan Paul, who has obtained 11 marks out of 15. Sri Sudip Datta has obtained 10 marks out of 15. Srimati Ratna Datta has obtained 7 out of 15. And Sri Devasis Lahiri has obtained 7 marks out of 15. Now the panel was Lordship forwarded that Lordship will find at page 26, the last paragraph, Lordship. The state selection committee, school selection committee forwarded it to the state selection committee. Last paragraph, now considering the matter in its integrity, the state selection board do hereby recommend the name of Sri Shankar Ranjan Paul for the post of principal, National HS School, Lamding. At the next part is relevant, Lordship, but then I'm reading, Lordship. At the same time, since Shankar Ranjan Paul has also been employed as serial number 1 along with Abdul Rauf, having scored 11 marks out of 15 in respect of Abdul Hasib HS School, Hojai, and since Shankar Ranjan Paul has been recommended for the post of principal, National HS School, Lamding, and accordingly, Sri Abdul Rauf is hereby recommended for the post of Abdul Hasib HS School, Hojai. This recommendation was there in favor of Sri Shankar Ranjan Paul for the post of principal, National HS School, Lordship. For the petitioner, Lordship. Now what had happened, Lordship? Lordship will see that the state selection board was headed by the chairman, who was the joint secretary to the government of Assam, Lordship, and subsequently the same person at page at the next page 27, Lordship, same person passed an order, Lordship. Herein it was said that in the middle portion, Lordship will find, in the instant case, has your Lordship got it?
Yes.
In the instant case, the Honorable Court came to the finding that the constitution of the SCC was not in conformity with the OM dated so and so, issued in conformity with the rules of 2003. In the school selection committee, instead of the vice principal or PG teacher, one assistant graduate teacher was appointed as the teacher representative. Though there is no infirmity regarding allotment of marks, but such deviation in respect of the constitution of SCC vitiates the entire process of selection. Now the last, I'm reading the whole. Upon perusal of the provisions of the aforesaid rules and the aforementioned OM and the direction passed by the Honorable Court by judgment and order dated 14/3/2018 passed in WBC number so and so, it is observed that the entire earlier process held on 14/12/2016 for selection to the post of regular principal, National HS School, Lamding, is vitiated, as the constitution of the SCC was not in conformity with the provisions of the rules of 2003. The concerned school selection committee authority may go fresh selection for the said post amongst those candidates who applied and participated earlier in complete compliance to the provisions of the rules, criteria, norms laid down through OM dated 6/6/2014 and the order of DSC Assam dated 23/6/2016. Now it is directed that the Inspector of Schools, Nagaon, shall constitute a new selection committee as per guidelines and may go for fresh selection for the said post amongst those candidates who applied and participated earlier in complete compliance to the provisions of the rules, criteria laid down through OM dated so and so and order of DSC. So new committee was constituted, Lordship, in terms of this order by the government, Lordship. Subsequently,
Oh, but he was a part of that selection committee.
Lordship,
He was the member of that selection committee.
no, I was a candidate for the principal of the.
No, this person who has passed this order, this joint secretary.
Lordship, I didn't get. I'm sorry, Lordship. Lordship, this joint secretary, earlier he recommended my name. Later on, Lordship, he said that there was a flaw in the process and Lordship, same person, Lordship. So I put it to challenge, Lordship. That's the reason why. Lordship, now what had happened, he's going to retire, Lordship, after in next year, Lordship, in November. Now, this new selection committee, which was constituted in terms of this order, Lordship, had Lordship recommended a panel Lordship. But that was kept under seal cover in terms of the direction of this court only, Lordship. Now, I pray that Lordship, that panel may be finalized, Lordship, in terms of the provisions of the rules, Lordship.
But is it in conformity with the Rule 13 of the Rule of 2003?
Earlier selection wherein I was recommended, I secured 11 marks out of 15, Lordship. They said that that selection committee was not in conformity to the rules. Now subsequently, in terms of this order dated 8/5/2019, the government constituted a new committee, Lordship, and I participated in that selection also, Lordship. Now a panel was prepared, Lordship, and along with me, the other candidates also participated, Lordship. So that panel, although prepared, Lordship, it was not forwarded by the school selection committee to the state selection committee, Lordship, as it was kept under seal cover in terms of the directions passed in this case, Lordship. Now, I pray that which was subsequently prepared, Lordship, that may be finalized, Lordship, because he is going to retire, Lordship.
No, is it in conformity with the rule?
The subsequent committee was in conformity to the rule.
With the rule?
Yes, Lordship.
But Mr. Sharma, you have challenged the letter dated 8/5/2019.
I did challenge it, Lordship, but then now time is short, Lordship. I am going to retire in November. So I am, Lordship, the other candidates, as per my knowledge, one Ratna Datta and one Sudeep Datta, who participated in the subsequent selection process, they had retired, Lordship, already. And I am also going to retire, Lordship. So at least for one.
Now you have abandoned this pair.
Yes, Lordship. If that prayer is allowed to finalize the selection process, I will abandon it, Lordship. Because I am going to retire, Lordship. Lordship will turn to
Who is for the respondent authorities?
Item number 59 for the respondent number 5.
Item number
15.
you go for respondent number 5. So what is your stand?
Okay, that's fine. Is retired. You is from and
Lucky get that. No, school selection committee.
So do you have any objection in the event of allowing his pair to finalize the list? Yes, so what is the extent of the department?
Okay, our difficulty is that we have filed our affidavit. Also at paragraph number 7, page 52, your Lordship. Paragraph 7, page 52.
Yes.
The Lordship, the opponent begs to say that pursuant to the selection of regular principal of National High Secondary School, announcing was made by following the Assam Education Provincial Service Rules 2003 as amended in 2012. However, prior to selection of the selection procedure new rule that is the Assam Secondary Education Provision Service Rule 2018 came into force. So far as the matter is concerned, before this honorable court and moreover, process of selection of regular principal and other personnel schools has been initiated as per a new set of rules. The Assam Secondary Education Provincialized School Service Rule 2018 as amended. Therefore, your deponent humbly prays that the court allow the deponent to withdraw the earlier selection process for the post of regular principal of National Higher Secondary School, Nagaon, by advertisement number so and so, Your Lordship. And further allow the deponent to initiate fresh process to appoint regular principal in so and so school, Your Lordship.
Now, madam, you see now the petitioner has abandoned his prayer.
But however, Your Lordship, when the petitioner was recommended by whichever committee, Your Lordship, that committee was not as per the rules, Your Lordship, and that's why it was reconstituted. And when it was reconstituted, the petitioner was not, he was in the fourth position, Your Lordship. After the constitution of the new committee,
I am in the panel, Lordship.
he was in the panel. Your
I
Lordship.
was in the panel, Lordship.
The panel is part of the record.
Yes,
Yes,
Lordship,
Your
page
Page
55.
number,
Yes, sir.
page number.
Page 55, Lordship.
Page 55, Your Lordship.
Okay.
Lordship, my reply to her problem with Lordship hearing, although the rules have changed, Lordship, but the effect of the rules of 2018 was given with effect from 18/9/2019, Lordship. 18/9/2019, by the time, Lordship, that memo or the notification of the government, Lordship, it was published prior to that, Lordship, so that validates my selection, Lordship. The notification which is at page 27, Lordship. This was published prior to that new rule came into force, Lordship.
Page number.
Page 27, Lordship. The government is into.
Okay, yes, madam, you obtain instruction. Who is your senior? Okay.
Lordship, they have also filed an affidavit. Lordship, in that affidavit, they have basically stated about the Lordship.
Page
my
number.
Lordship, it starts at page 29, Lordship.
29.
They have basically stated that the selection committee was, the earlier selection committee was not in conformity to the rules, Lordship. And since that was not within the parameters of the rules, the committee had to be reconstituted, and the other process which was there, that was done, Lordship. That they basically said that only in that. Subsequent process as directed under the provisions given in page 27 by the government, Lordship. They have complied with that, Lordship. Almost.
Okay. Yes, Mr. Nandi, what is your stand here?
Yes, item number 50.
Yes.
And here, what they have stated, that this very litigation itself is, my lord, there is,
the petitioner claims that he has been selected by the school selection committee. But that school selection committee itself is incompetent. Because the graduate teachers have not been taken up, postgraduate teachers, there are 6 numbers of teachers. And the school selection committee is constituted by the one graduate teacher and another is pre-university teacher, pre-university pass, undergraduate teacher. I have already mentioned in my affidavit that the very school selection committee is in total violation of the for selection of the principal.
No, Mr. Nandi, you see, the petitioner has challenged the page number 43, Annexure A. The letter dated 8/5/2019.
Twenty-seven.
8/5/2019.
My lord, so far as this number 4, that is 8/2019 is concerned, the own department has said that the selection committee is not duly constituted.
No, Mr. Nandi, you see, the petitioner has challenged this letter dated 8/5/2019
Yes.
in his pair number 1 of the writ petition, and now he has abandoned this pair.
My lord, let there be a properly constituted school selection committee and then let the
No, now he has withdrawn his challenge to this letter.
Lordship, they, in their affidavit, they have not faulted with the second reconstituted committee, Lordship. So that may be finalized, Lordship. The panel prepared and subsequent recommendation.
my lord,
Then you obtain instruction
is
in respect of this.
let
When to be listed?
me see after the winter vacations.
But the petitioner is going to be retired when?
November, Lordship, next year.
2026.
Yes, Lordship.
Let it be in the month of January then.
Yes.
Heard Mr. MP Sharma,
will
learned
keep it as
counsel for
part
the
of-
petitioner.
Go ahead.
And Ms. D. Musahari, learned standing counsel for the respondent in secondary education department, and Mr. Nandi for respondent number 4 and 5, or
Yes.
5.
5.
Respondent number 5.
Only 5.
5, Lordship.
Only 5.
Only 45. Respondent.
During the course of deliberation, Mr. Sharma, learned counsel for the petitioner, submits that the petitioner has challenged the letter dated 8/5/2019. But the petitioner is willing to abandon the said pair, and as such, the selection list so prepared may be finalized and be given effect to. Mr. Nandi, learned counsel for the respondent number 5, submits that he may be granted some time to obtain instruction from the respondent number 5. Pair allowed, recess and list the matter as part heard on first week of January.
9th of January.
9th of January.
I'm obliged, Lordship.
NCT, okay. 16.
Mention.
Oh. The petitioner.
Yeah. In both people, my lord, yeah, the full.
Lordship, it's connected, Lordship, because page 26, the recommendation, we both secured 11 marks out of 15. And his name was recommended in Abdul Hasib HS School, Lordship. So that was put to challenge in the subsequent petition.
My lord, usually, my lord, not the equal mark, lord, I secured more marks than him, Just my lord, here, send my appointment letter.
Lordship, I'm not pressing it now. Let it be kept open, Lordship.
If he is not
Till-
pressing, my lord, then it will be closed, my lord. Unnecessary, I am.
Okay, let it be on 9th of January. On that day, we will dispose of both the petition.
Right, Lord.
Me, leader losses, my lord, I'm so sorry to say that I have a one matter motion, that I have that it is after vacation. Actually, case like your office is better to obtain instruction because I have not received salary.
17.
And I want interim order. Can it taken up this matter right now? Item
Not now at 2 p.m.
Then Wednesday, madam.
Wednesday.
First in code number 5.
Oh, what to do? No one appeared.
No, madam, my ears were suffering. I have a but they were suffering fever, madam.
Okay, then take a date from him. When do you want?
Milord, we are similarly, Milord, extremely sorry, Milord. Item number 44, we have missed, Milord. Some urgency is there. Can it be taken day after tomorrow, Milord? Or Milord, 19, Milord.
Okay, day after tomorrow.
Deep blue.
Wait,
17.
it's a Muslim meter.
Milord, let it be on 19, Milord.
Okay, 19th.
Deep blue, please.
Wait, Lordship, we missed the item number 5, Lordship. It is very important matter, Lordship. We missed the item. The meter may kindly be fixed on Wednesday, Lordship. Okay. Lordship. Obliged. Sorry. Right, Lordship. But I'm actually sorry for that, Lordship. The bank item number 13, Lordship. So, if can, I think possible, Lordship, can Lordship.
When?
Item number 13, Lordship, the kindly fix the date after vacation. Any other
Take a date from him.
Second is any other day.
Take a date from
Yeah,
him.
take it, pass away.
And if it
Next
is 46 is not taken to the Milord, that may be also come after tomorrow, Milord.
Okay.
17, 12.
46.
17, 12. 17 of December. Item number 50, timing meter.
10 minutes.
I'm really sorry, my lord, because of the traffic jam, nowhere can go, Lordship. I'm stuck up there, Lordship. So what happened, Lordship, that day has a specific query, whether below 70% someone appeared. I took the instruction, no one.
No, on the other day, you have referred to one of the provision.
That is
No, sorry,
earlier,
one of
Lordship. That is earlier the first day. That is first day, as per the controllers, Lordship, controllers has given 2 names. Then controllers is also withdrawn.
On 9/12.
On 9/12, controllers withdrawn. It's a matter of record, Lordship. Lordship can see. Just before the page 70 and page 71, 2 letters.
71.
Page 70 first.
Yes.
That a group of students of so-and-so come understand so-and-so for permission to appear in the exam below attendance below 70% with the favor of so-and-so. The students came in a group and appeared in the area, desperate as the letter come without any note from the principal and state approval will state the year. It is now decided that the students should not be allowed to appear in the final exam as they do not have the required attendance percentage. That is first. That is, Lordship, now please come to page 49. Lordship, may please come to page 49. This 49 is given by one Ankita Goswami. And 51 is Zabar Rahmatullah. 49, Lordship, get it? And then 51. 51, 51.
Hmm.
Both these was allowed by Guwahati University.
Hmm.
Both of them. Now, Lordship, please come to page 71. They have been withdrawn. There is no one now. And after that, I have been suspended. Page 71, Ankita Goswami and Jalen Ramanullah. It is withdrawn, and withdrawn why? The last line. The above is withdrawn as per the suggestion and input of the principal BRM Government College. My suggestion, Lordship. I have given, because I have decided, Lordship on 5, Lordship has decided the writ petition. On 6, I have disposed of their year that I will not allow below 70%. They have given a representation. Lordship in your judgment, Lordship said that consider the representation. I considered the representation. I said no, below 70% I will not allow. And after that, Lordship, page 71, university has also withdrawn. That we have allowed. My stand is very clear at page 63, Lordship. I have informed everybody. Page 63. It may be mentioned, page 2nd paragraph, Lordship.
Hmm.
It may be mentioned here that as per Rule 12 of the Bar Council, in the students having 70% attendance only can appear in the examination. In spite of the informing all several times, these students did not attend their classes. It is to the Secretary Higher Education, Lordship can take note, this letter, and copy to the Director of Higher Education, Government of Assam, in the last year. Then, in the page 63, it says on 6/12, Lordship, I have specifically mentioned the faculty submitted attendance report before form fill-up, and eligible candidates are allowed to appear in the examination on the basis of those reports. Examination has already started and it is going on smoothly. So on 6th, after my representation, I have decided, I have informed everyone my stand. Lordship had decided on 5/12, that judgment, Lordship at page 56. Page 56, Lordship judgment.
Okay.
And Lordship directed me that dispose of the representation, this is 9/11/25. I dispose of the representation at page 61
Hmm.
as per Lordship judgment, as per Lordship direction. And I said, no, I will not allow anyone below 70%.
Hmm.
And I have informed Secretary, I have informed Director of Higher Education, both. And on after my disposal of the representation, as per Lordship judgment, even the university has withdrawn both of them. Because as per the Bar Council rule, Lordship can see, Lordship has quoted in Lordship judgment that it is the university and the principal can allow someone to appear. Lordship, may please come to page 59.
Okay, on the other day, you have shown that provision to me.
Lordship,
On the other day, you have shown the provision to me.
yes. So that's my humble submission, Lordship. And then, Lordship, after following the court's judgment, Lordship, one should not suffer. And then I have specifically made on oath that below 70% now no one is appearing. And I took the instruction after the Friday, Lordship, that on the 2nd day when the university has withdrawn, both that too, there is no one has appeared on the second examination. Below 17. That is my para 19 at page 17, Lordship. I have already on oath, I have stated. Para 19, page 17. Para 19, page 17.
Okay.
And in the inquiry report, Lordship, there is not a whisper against my client, Lordship. There is nothing.
Yes, does anything to submit?
On last occasion, Malad has already heard the matter left Malad. And after hearing both the parties, Malad, there is to Bring the records, my lord.
No, whether the records are required to decide the issue.
Attendance register of the,
Hmm,
which is in the custody of the petitioner.
hmm.
They have to review everything, my lord. So my humble submission to the going to the records, my lord, needs to pass in the moderator of the petitioner.
Okay, we will pass the order.
I'm grateful, Lord. Report, Lordship, is very clear. Report is said after going through the attendance register, all record this report, Lordship. So it is not the report.
Regarding this alternative remedy, my lord. Because since there is an appeal, my lord, for suspension, those 14, my lord.
Maybe that may not be applicable in all the cases.
And maybe I just raise the judgment for the minor, have a look.
How you can produce? That alternative remedy is not always applicable when
That
the
my reading is
fundamental
already
right
there.
is violated.
My submission, there is a provision
Yes, there is a-
relative to, for appeal, my lord. So the petitioner ought to have, assumed death, for us before approaching before this honorable.
Okay, you produce the judgment.
Item number 17.
So, Lordship, for that alternative remedy, only one judgment, direct judgment on this point also. Para 7. Where the order or the proceedings are wholly without jurisdiction, then the alternative remedy point will not come. This is direct, Lordship. Para 7. Whirlpool is there already.
Item 17.
Yes,
Lordship, in this matter, I'm appearing for the, my lord, the petitioner herein, my lord, is a candidate of, my lord, the combined competitive services examination, my lord. And, my lord, he had appeared, my lord, and in this case, my lord, after getting the RTI report, he came to know his score was 901, my lord. He had applied for the post of labor inspector. Now, my lord, the cutoff for the cutoff, if your lordship sees, for the post of labor inspector in the particular CC was 901 itself, my lord, and that then the petitioner got the same marks as the respondent number 8, my lord. Now, my lord, what has happened is we have filed a reply to both the affidavits filed by the APSC as well as the private respondents. But however, my lord, I would like to place one just my lord, issue which I would like to raise before your lordship is that we have a dispute. Lordship will kindly see, I've given a chart. There's a chart annexed to the petition, my lord. There's a chart in the, my lord, file. This is the, my lord, judgment, my lord. First, my lord, a judgment of Rishikesh Das, my lord. Rishikesh Das, my lord. Here, my lord, similar case, my lord, of undermarking, my lord. Like how we have got undermarking, my lord. Here, my lord, when there was an undermarking, since it is an academic question, my lord, the court was prima facie of the view that even after writing the right answer, an independent inquiry was made. Because of the fact that the APSC had not given in the affidavit as to what is the correct answer. If that is not the right answer, what is the correct answer? So, lordship kindly sees the order, my lord. It is dated 19/6/18. The writ petitioner herein had participated in the competitive examination held by the APSC pursuant to the advertisement notice dated so and so. But when the results were declared, the petitioner was not selected since he had failed to secure cutoff marks for being appointed against any of the posts mentioned in the notice. Aggrieved thereby, the petitioner had made an application under RTI Act 2005 before the APSC requesting for copies of the answer scripts, which were furnished to him. On the examination of the answer script, the petitioner found that the marks given by the examiner in respect of as many as 7 questions in general studies paper were erroneous and or were inconsistent with marking instructions set out in the question paper. Hence, this writ petition seeking the intervention of this honorable court. After hearing the arguments advanced by the learned counsels appearing for the parties, this court had passed order dated 5/6/18, granting time to learned counsel APSC to obtain an instruction as to whether APSC would open to taking an independent view on the controversial answers and fresh marks to be to the petitioner in accordance with the merit of the answers. Today, when the matter is called up, Mr. Borua has produced a copy of the written instruction dated so and so, issued by the Secretary APSC, wherein it has been stated that in view of provision so and so, the commission will not entertain the request for re-examination of the answer scripts. Now, my lord, this part is crucial. This part is crucial. During the course of the hearing of this case, this court has meticulously examined the materials available on record, including the question papers of the general studies paper and the answer scripts furnished to the writ petitioner, under RTI Act 2005, which has annexed to the writ petition. From threadbare scrutiny of the same, this court is of the prima facie view that there are anomalies in the awarding of marks to the petitioner in the respect of these questions, my lord. So and so in the general studies paper. Therefore, for the ends of justice, a correct and independent assessment of the answer script be given by the petitioner against those questions would be necessary for passing any further order in this writ petition. Since the APSC is reluctant to make assessment of the answer script based on the complaint of the petitioner, this court is left with no other option but to refer the matter for an academic opinion, expert opinion. Registry is therefore directed to forward a copy of this order to the general studies paper, question paper, and answer script of the petitioner to the Vice Chancellor so and so, Cotton University, Guwahati, in seal cover through special messenger. The learned Vice Chancellor is requested to get the answer script of the petitioner re-evaluated, re-examined through competent academician of his church with regard to the answers of the so and so. And then, my lord, they have given the opinion of the expert is to be sent back to this court in seal cover. So, my lord, my prayer over here is, my lordship will kindly go through the chart which I have given, my lord, which is annexed in the I have given in the during the motion stage only. It is, I think, in the writ petition, my lord, which is annexed in the petition. There, my lord, I have
Page
given
number?
the
Page number.
my lord, it's not page. I have given the court had asked me to make a chart. I had given a chart, my lord, in the last occasion. The lordship, since the and you see, my lord, it is there, my lord.
Okay.
Yes, my lord. So the question out here, my lord, is only one question. In unlike the other case, there are 7 questions. There are only one question, my lord. The question is, my lord, I did. It's an English question, my lord. English question paper, my lord. 6D5. You also got it, my lord. 6D5.
Yes.
The page number of the question is, if your lordship takes up the writ petition, is at page 80. Your lordship takes up page 80 of the writ petition. There, your lordship will find the question paper of the Assam Public Service, page 80. This is a very simple question, my lord. My lord, no, I'm not going for hearing, my lord. I am just wanting a independent inquiry. My lord, let me complete. My lord, it's not. I'm not going for hearing, my lord. I'm not going for hearing, my lord. I'm only praying for an independent inquiry as per that order, my lord. Because if it goes for hearing, my lord, I cannot ask for. I cannot ask for, my lord. I cannot ask for. My lord, I have to go prepare and to counter that. My lord, he should have come prepared, my lord. The cases come beforehand, my lord. He has come to know Friday list has come out, my lord. Friday list has come out, my lord. Monday. Monday, my lord. How can he ask for, my lord? Lordship, I am asking for an, my lord, I am asking for an independent inquiry where they are not concerned. An independent, my lord, inquiry, like that order, my lord. Lordship, kindly see this, my lord. First see the question, my lord. The question is, my lord, 6D5 at page 80. The question is, I did not feel very well yesterday. It's a very simple question. I did not feel very well yesterday, but I dash better today. So the question is, my lord, rewrite the following sentences, my lord, and my lord, it has been given. Fill in the blanks with the correct tense form. Feel.
So, Pukon, no?
My lord.
Let them come with their instruction.
Well, they already
Fill for the
filed the
respondent
affidavit.
number 7 and
But they
8
have
are
already
also
filed their
not
affidavit. They
available.
have already filed their affidavit. The instruction already is there in the affidavit. We have filed a reply also. But
Maybe.
only thing we require, my lord, is that we want an independent, my lord, inquiry just like the other
No.
order, which I have placed before your lordship.
Mr. Pukon, her senior is absent today.
My lord, she is the private respondent, my lord. I am asking because, my lord,
Because
my
you
lord,
could be a partner. No, he could be a partner.
then, my lord,
When you are
but this will be crucial, my lord.
But when your senior will be available?
My lord, that's not.
You will be next week only.
Next
See, my
week,
lord, vacation, my lord.
vacation
That's why
start.
I'm saying, that's why I'm saying, my lord. After vacation, my lord, it will be a problem, my lord.
I think the last day.
No, my lord, it can be, my lord, and it's a, my lord, covered case. One thing, my lord, I would like to say is that I'm just asking for an independent inquiry, and I have got an order which is from a coordinate bench, which has directed, my lord, in case of a APSC matter for undermarking. Undermarking cases, my lord, academic opinion of a academic expert is very much crucial, because, my lord, in that particular case, which I have shown, my lord, this particular case went up to Supreme Court, my lord, and fortunately I was in that case, my lord. This case was reported both in GLT, my lord, as well as in SSC, my lord. Kindly see, my lord. Rishikesh,
No, that's all right. But let them obtain their instruction.
my lord, but
Especially
my lord, what instruction, my lord?
doctor.
My lord, but this is court's situation.
Let me go, I will respond on that point also.
My lord, my lord,
15 appointment, they select 2022.
that is a different thing, my lord.
What is the high lordship? for
And the merit is there, my lord. There is merit in the case, my lord. My
Okay.
client, my lord, got 901 marks, my lord. My client wrote the correct answer. He was denied the correct answer, because of which, my lord, the private respondent number, who's a blue-eyed candidate, private respondent number 8, he was selected. I have prima facie made out a case, my lord. And that is why I'm saying, my lord, I'm praying for an order, my lord, similar to that, my lord, where the court, my lord, saw the marks. That's why I'm showing the, my lord, that's
No,
why
no,
just one question.
answer script were examined by the examiner.
Exactly, my lord. And
Then-
after writing the right answer, they give 0. If your lordship sees, I did not feel very well yesterday, but I dash better today. Fill in the blanks with the correct tense form. I have given the
Okay,
answer given by the
Mr. Fukan, on
My lord.
next that we will say. In the meantime, Doctor will
My lord,
obtain necessary instruction. Let it be in the first week of January. That's it. Heard Mr. Fukan, learned counsel for the petitioner. And also heard Mr. Dotto, learned standing counsel for the respondent in APSC. And Ms. Learned counsel for the respondent number 7 and 8. Mr. Fukan, learned counsel for the petitioner producing one order dated 19/6/2018, passed by a coordinate bench of this court in WPC number 5576 of 2017, submits that an independent inquiry
my lord, independent inquiry
inquiry
to be conducted for the disputed
may
question.
be directed to examine the question.
Question
Wherein-
65.
Examine the question number 65, wherein the petitioner has given the right answer, but he has not been given the required mark. Required mark. Mr. Dotto, learned standing counsel for the respondent being APSC, submits that he may be granted on time to response to the pair being made by the petitioner for an independent inquiry. The learned counsel appearing for the respondent number 7 and 8 also submits that her senior is out of station and she pays for listing the matter in the next week. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess will list the matter on 5th of January.
Can it be on 6th, my lord? 6th Tuesday?
Okay, 6.
6th of January.
6. In the meantime, Mr. Dotto obtain necessary instruction and apprise this court about the pair being made by the petitioner today.
Item number 18.
Deeply obliged.
This my lord, but from Mr. Deepu is a very difficult my lord. But in another.
Okay, after some time.
Item 19.
This IA has been listed. We have prayed for production of some records, my lord, and they took time on several occasions.
Principal case.
I is for what purpose?
My lord, because initially we were appointed, my lord, in the year 1994.
For this file and then that particular file is not traceable, that is the clause that I am. That is the instruction.
Yes, my lord, then IA may be closed, my lord, and matter may be heard, my lord, on merit, if there are no records.
So whether you have filed your affidavit?
In I do not file with.
In the main petition?
Main case, they have filed, my lord. In the main case, they have filed.
As per the about FI around 9/24 matter. This matter may take up immediately after because of the biotic. That's the matter.
The matter is, my lord, both of us were appointed in the year 1994. We received salary for some period. Then pursuant to some screening process, our appointment, we have been reappointed in the year 2021. And with a condition that we will not be covered under the old pensions rules, and therefore we have approached this honorable court, my lord, with a prayer for directing the authority to consider our case for old pension scheme and payment of arrear salary. And my lord, we have been paid fixed salary only, my lord.
Heard Mr. N. Sharma, learned counsel for the applicant and also the petitioner.
Yes, my lord, petition.
Applicant in
petition.
I number 1283 of 2024 in WPC number 6061 of 2023. And also heard Ms. Sophia, learned standing counsel for the respondent in elementary education department. This interlocutory application number 1283 of 2024 is filed by the applicant, who is the petitioner in WPC number so and so, for directing the respondent authorities to produce the record pertaining to file number ELC/CR/CR number 711/97/096-538 between bracket part 2, process in the judicial department and the legal cell between bracket elementary education department for proper adjudication of the matter. Today, Ms. Sotia, learned dissenting counsel for the elementary education department, has produced one letter of the joint secretary to the Gupta Assam Department of School Education dated there is no date in this letter. When this letter was written by the joint secretary?
22/5/2025.
Where it is written, date?
Last part of me.
Last part, my lord.
Last part?
What is it? That to that.
Five four 25. Dated nil. And submits that the record could not be produced as the same is found to be missing, and in that regard, one FIR has been lodged with the Dispur Police Station by letter number E 06667/5 dated 9/12/2024. And Ms. Sutia further submits that the matter may be listed immediately after reopening of the vacation, so that she can obtain up-to-date instruction in respect of the said file. They are allowed recess and list the matter on 5th of January. In the event of filing to produce the relevant file on that day, the court will proceed to hear and dispose of the writ petition number 6061 of 2023 on the basis of materials placed on record. List accordingly. After?
21.
Matter may be kept as part of, you will lodge it to the heart.
Recess and list the matter as part of.
Item number 20.
May I please allow?
Matter relating to promotion matter.
Relating to?
Promotion matter.
From?
Instruction that required from the director unities. I am agreed for as soon as 625 like that.
Or
Since my lord, long pending, this petition, my lord, maybe, my lord. Otherwise, my lord, it may be disposed of, my lord, I file a representation, my lord, before the respondent.
when?
My lord, annex I, my lord, page 59. Maybe dispose of, my lord. Page 59, my lord. By examining all the facts and materials on record, my lord.
Let them get the instruction first, Malab. Here is a long contesting matter, Malab. 4 rounds of litigation are already over. Malab, another writ petition also, Malab, pending, whereby Lordship has stayed the, Malab, the last transfer order. So far, response number 6 is concerned. So far, here the issue is concerned, Malab, confirmation in service. As per rule, Malab, 4 of Assam Elementary Education Provincial Service Rule, Malab, 1981. The respondent numbers 4, 6 has been confirmed in the particular
No, no,
school.
Mr. Das, if we dispose of this petition by directing the respondent authority to dispose of the representation, whether any prejudice will be caused to you?
In that case, my lord may aid, my lord, by granting opportunity to both the petitioner as well as the 6th. Opportunity of being heard by the director eliminated.
But they filed evidence before a head teacher.
Oh. Head teacher, they filed the report.
It's on 69 was.
Should be, it should be director eliminated division. Human basis. This is regarding.
Page
inquiry
50,
report.
page 50 or page 60, my lord. 60. This is before District Elementary Education Officer Dibrugarh, my lord. My lord, I am the senior most trained and graduate teacher. Respondent number 6 already filed round and round litigation by suppressing all the material facts. It's on record, my lord. So, my lord, matter may be disposed of, my lord, by the respondent authority by disposing this my application, my lord. On the basis of facts and materials on record, my lord. It is clear, my lord. It itself clear, my lord, in an inquiry report, my lord, page number 69, where, my lord, respondent number 6
No,
and
if
petitioner both
we are
appeared,
to
my lord.
dispose of this representation. No, dispose of this petition by directing the respondent to dispose of your representation, then why should we go to the merit?
Yes, ma'am.
Well, since
And if you want
to
to,
merit, my lord, then my lord, we have to hard, my lord.
if you want the matter to be adjudicated on merit,
Yes.
then let them obtain instruction.
my lord, obliged, my lord. I am obliged.
Mr. Egumai, learned counsel for the petitioner. Mr. Das, learned counsel for the respondent number.
6.
Respondent number 6, Ms. Sophia, learned standing counsel for the respondent in Elementary Education Department. Ms. Sophia submits that her instructions are still awaited. Accordingly, it is provided that registration lays the matter on. After the
23rd of January.
23rd.
Right, my lord, in January, my lord. Long pending matter, my
Only the
lord.
day after. After 23rd, perhaps is holiday. ma'am.
27.
Maybe on
28,
27th.
28 or something.
Yes.
28. In the meantime, Ms. Sutia shall obtain instruction and also file her affidavit in opposition.
Time being item number 18.
But in this matter, this next for hearing, NJ is appearing, so there is some personal difficulty.
Who is appearing?
NJ Khatarian.
Sonia.
There's some personal difficulty. I have taken his consent, so they agreed. We agreeing, that date may be fixed, but not immediately after the vacation.
Okay.
Maybe
As
22nd
agreed
January,
upon, learned counsel for both the parties, recessal is the matter. After vacation.
After the 22nd January.
21st.
21st. April.
21.
My lord, this matter relates to sharing of UGC grants, my lord. Petitioner and the private respondents were appointed by the Kolliabor College against the UGC vocational subject of tourism and service industry and small tree garden management. There are two stream, my lord. Both of us were appointed by the college against the subject of tourism and service industry. My lord, my appointment order, my lord, page 34 is the appointment order of the private respondent. The UGC has introduced the scheme of vocational subject. Then against the scheme, the private respondent was appointed on 26 May 2025 on fixed pay basis, on contextual basis. Then, since one teacher is not possible to serve all the students, then I was appointed as per advertisement page 35, middle portion, Kolliabor College, walk-in interview is arranged.
Whether all the parties have filed their affidavit? in
Yes, my lord.
opposition?
Yeah,
Filed.
we have also filed reply, my lord. Only problem is that when the UGC has sanctioned the amount, around 29 lakhs of amount in the name of the college, not in the name of the individual. The UGC has sanctioned the amount in the name of the college, then college has disbursed the, college should disburse the amount among two of us. Instead of doing that, the entire amount has been paid to the private respondent. That is my grievance. We are deciding say similar duties. Our nature of appointments are also similar. And they have admitted that one teacher cannot perform the 4 classes, and therefore, as per their resolution, as per their advertisement, I was also appointed. So if the UGC has sanctioned some amount, that should be shared by both of us, my lord. This is my limited grievances. And before that, the college authority should take a decision why I am deprived of my legitimate claim, my lord. College has also admitted that one teacher is not possible to teach all the students. And UGC also submitted that the amount has been sanctioned in the name of the college, not in the name of any individual. Page 43, the amount has been sanctioned to Anuradha Hazam. 29,55,000. The private respondent and college has taken a stand that my appointment was later than the private respondent. Except that there is no other grounds has been assigned.
Where is the impugned letter?
My impugned letter is page 41. Principal stated that only one teacher is eligible for receive the grant in aid. And since I was appointed after the private respondent, so I am not eligible for the amount.
So is there any criteria for allowing this honorarium?
Well, as per their scheme, my lord, they have launched a scheme UGC scheme started from page 16. This is the scheme guideline for introduction of Bachelor of Vocation and
So the private respondent is also working in the same department.
same department, both of us. because one teacher cannot teach all the 4 classes. They have admitted. Therefore, I was appointed in the next year.
Who is senior? You or the
Right.
private respondent?
Private respondent is senior, but there is no criteria for who is senior, who is appointed against first post. There is no such mention in the UGC guidelines, my lord. One teacher is eligible, but who will be the one teacher? Both of us are discharging similar nature of work. At least I
No,
should get.
if it is sanctioned in respect of only one teacher, can it be divided among two
Yes,
teachers?
that should be done, my lord, by the college authority.
No, whether the UGC guidelines provides for.
My lord, UGC guideline has said that in the name of the college, they will disburse the amount to any one of us. My lord, only one teacher, my lord. After her term is over, I was appointed against the same post. Page 35, this is the advertisement. And in her appointment also, there is no mention that she is the only teacher to receive the UGC grants. Page 34. There is no such mention that she is entitled to receive the UGC grants. Same terms and condition, page 34 and 36.
Before going to the merit, if he is agree, lordship, I am paying on behalf of the national college, lordship.
Main authority.
National college on behalf of the principal, lordship. On merit, lordship, he is not entitled a single penny, lordship. He knows also, as a lordship, because there is no, in the advertisement, there is no mention that from the college authority fund, a consultation I am given to the board of business. There in advertisement, lordship. The part of in 2014 is this scheme was has revealed a big hawk scheme, you introduced big hawk scheme, and you appoint one teacher. After this scheme, the college authority appoint one teacher, and though the advertisement it has written that you will get the all entire money, but the scheme was for only one teacher. After 2 years.
No, where it is provided, it is for only one teacher.
In 2014 scheme, lordship,
Page number?
I have an point in my revision position, number 5, page 75.
75.
My revision opposition. This 75 was like activity opposition.
Yes.
Financial assistance. 11.2.
Hmm.
Then again, the same guideline page 93. Letter of system.
So here it is provided that one associate professor and 2 assistant professors.
And now your machine, then kindly turn on to page 93.
Yes.
Clause 5, nature of the system. I'll go to that.
Hmm.
An institution may be allowed to run 2 courses in the beginning. However, based on the effective implementation of the scheme by the institution, additional courses will be approved under the scheme. The financial allocation will be made by UGC with the overall ceiling of rupees 1.70 crore for a period of 3 years under different heads, initially for 2 courses. However, a grant of rupees such and such for one assistant professor will be paid for each additional course, making a total of such and such maximum. Startup assistant. And one-time startup assistant up to rupees such and such for setting up of laboratory such and such.
5.2.
Then 5.2. Accounting, one assistant professor per course. Up to rupees 65 such and such. 3 years purely on contextual basis to be reimbursed on actual receipts within the total allocation, institution should report faculty only in the 4 trades being offered under the scheme. So as per guidelines, she is not entitled.
No problem. Admittedly, I have appointed another because this in the advertisement, in the second advertisement, which he is claiming, in the second one, it has been clearly mentioned that college will pay anyone, and she is getting 10,000 from college. Now, what I propose to say, yes, the both of the our ladies are working in my department, or chief, as a principal. I am going to try that if some outside the court, lordship, if mediation may be referred, lordship, and then some amount may be given to her. She is also agree with that which she is getting 29 lakhs getting apart from 25 lakhs. If she apart some to her. Then
Malat page, just of page 125, the affidavit filed by the governing body. It is stated that it was not possible to teach the student by one assistant teacher. Therefore, I was appointed against the same post. There are 2 number of teachers are working against.
But Mr. Sharma, it appears that the scheme is only for one associate.
Well, who will be that one, my lord? There is no such order passed by the authority that the senior most will be the only teacher who will be eligible. Even
No,
the
anyway, they are trying to
Yes, my lord.
settle the matter amicably.
simply kindly direction to take up the matter
with the principal, my
to
lord.
the principal and amicably settle, and the affidavit will be filed before this court.
Yes, that can be done. If matter may be kept pending, my lord.
Okay.
Only simple direction, the petitioner will take the, principal will take this matter, direction of direction. Permit, lordship.
Petitioner will be,
No, lordship.
Principal will be
Principal will
directed.
Take the matter, lordship.
In presence of both of
No,
us.
whether at this stage we can issue such direction.
Otherwise, we will not get, nothing will get. She will get.
What I, as so far my instructions concerned, so far lawyer, it's sometimes she is not, but end of justice,
End of that.
up to some, I may, but end of law, she is not entitled. So now, principal wanted that he may be permitted to take up the matter with full fiction and the paper. That may be permitted.
Out of 20 lakh.
No. You settle the matter amongst yourselves and apprise this court on next day by filing an affidavit.
Yes, ma'am.
Some reflection in the.
No,
Order you want.
that kind of direction cannot be issued.
Direction, but he is permitted, that much.
Permission may not.
Principal is permitted to take up the matter outside.
Heard, Mr. N. Sharma, learned counsel for the petitioner. Mr. Mohanto for respondent number
3, lordship.
D. Mohanto for respondent number 3. Mr. Ayuddin for respondent number 5. Anybody for CGC? No.
UGC.
Some way, some way.
CGC or UGC?
UGC.
Here it is written as CGC. Okay. UGC? A semua. UGC.
That's one number 4.
And for higher education department? Miss so and so, so and so. For higher education department. During the course of deliberation, Mr. D. Mohanto learned counsel appearing for the principal, respondent number 3, apprised this court that an effort is being made to settle the issue amicably, and the principal may be granted some time to take the matter to a logical conclusion, and also to grant some time. Pair is accordingly allowed to raise the matter on 21 January.
Lordship, can you be,
21 yes.
May I pray for taking up the matter as part?
Yes.
Number of matter come up before only.
in month of February, lordship, I
No,
don't know.
January.
Month ago.
After before vacation.
Before,
After giving any.
after yes.
Dated at
28.
raise the matter as part.
December 22.
Well, from there.
May please, Your Lordship. Petitioner before your lordship was a stipendiary teacher initially appointed on 5/12/2029, 1999. Annexure 1, page 22. Page 22, annexure 1, lordship will find date of appointment 4/12/1999. Lordship got it.
Page number
Page 22,
20.
annexure 1. This is the initial appointment as stipendiary teacher. Married lordship. Subject to the discharge without a notice and assigning any reason thereof, Sri Choneshwari Borsi.
No, Mr. Dhar,
Lordship.
whether all the parties are before this court
Yes, lordship.
and
No
affidavits
private
are
is
available?
not there. BTC is there. Private
BTC.
respondent is not there. There is no private respondent, only the government.
Okay. Madam, you are for BTC.
And we have filed our affidavit matter.
Hmm.
Lordship, in our affidavit matter, we have already stated that proposal has been sent to the elementary education matter that whether he was accommodated as teacher matter. So whether he can be accommodated for the post of assistant teacher. We have sent a proposal on 8/1/2025, my lord. And now, my lord, that has to come from the government, my lord, the sanction, my lord.
Where is that letter?
Lordship, in our affidavit at page 51, my lord.
51.
There were series of communication. This communication remains in files, lordship.
Lordship will find that a fresh proposal for accommodation of teacher instead of tutor, along with inquiry report of training certificate of in respect of the petitioner. Lordship has been sent to from the Director of Education to the Department of School Education Secretary.
Okay, Mr. Pegu, you have received this letter?
Yes, I have seen the letter, earlier the proposal department has signed it, requested to submit the proposal, and now
When he was asked to resubmit the proposal?
August 2024.
25.
24.
24.
It is 20.
But this is the latest 18th of January, 8th of January 2025.
And it will take the status for other things.
Lordship, they are seeking time for taking instruction and no instruction has been placed before your lordship. So lordship may dispose it of because lordship in this similar nature of case, lordship has disposed of another case, lordship. Lordship, interestingly, lordship, I was engaged as stipendiary teacher and the second paragraph of that letter order at page 22.
No, that's all right, but they have already started communication. And
Communications, they are doing communication and it remains in the file, lordship. No action has been taken. I was appointed as stipendiary, then I was regularized in 2003. Thereafter, my service book was opened, GPF account was opened. Subsequently, on 2009, I was terminated from service without showing any cause. No explanation has been given. I have not been heard. Nothing, straight away I was terminated. Again, in 2015, I was reinstated in service. Thereafter, in 22, I was placed as tutor, appointed as tutor. Then again, I have been regularized in 22. Now, what communication is required from the Director of Limited Education, lordship, or the government? It is the BTC authority who is the appointing authority, Director of Education BTC.
BTC.
Yes.
But approval from the government.
No, they have to take approval from the government.
Lordship, if your lordship comes. What financial matter? This regularization was against EA.
Okay, let it be in the first week of January. In the meantime, he will obtain instruction in respect of this letter dated 8th of January 2025. Heard, Mr. N. Dhar, Learned Counsel for the petitioner. And Ms. Bora, learned standing counsel for the BTC, and Mr. Pegu, learned standing counsel for the respondent in Elementary Education Department. During the course of deliberation, Ms. Bora has pointed out to a letter dated 8th of January 2025, written by the Director Education, BTC Kokrajhar, to the Secretary to the Govt of Assam Department of School Education. Whereby a proposal for accommodation of teachers instead of tutor, along with inquiry report of training certificate in respect of the present petitioner, is submitted. Then the outcome of the said communication has not yet been made available to the respondent in BTC. Mr. Pegu, learned standing counsel for the respondent in Elementary Education Department, submits that he may be granted some time to obtain instruction in respect of the letter dated 8th of January 2025. Where is accordingly allowed recessal is the matter on 9th of January as per her.
Last chance lawsuit.
Okay, in the event of failing to produce any instruction in respect of the letter dated 8th of January 2025, the court will proceed to hear and dispose of this petition on the basis of
If this matter is part
materials
heard,
available on the record.
Lordship may keep this matter as part heard.
Okay, perfect.
Lordship, duly applied.
Under the telecommunication department. Subsequently, on 27/5/1996, he was conferred the temporary status Mazdoor Malad. Since then, he was working in the year 2016. He was implicated in a criminal case, Malad. Malad, he was arrested and subsequently he was released on bail. By judgment and ordered, judgment dated 7/8/2018, Malad, the trial court has acquitted him with a direction, with a observation that the prosecution has failed to prove the case, Malad. Thereafter, he was not allowed to join in the service, Malad. Lordship will find that trial court order at page starts at
Who is for the respondent?
respondent, my lord, telecommunication.
Preparing for the respondent, but 226 for the
Well.
PS lordship. Otherwise, this repetition is not maintained is forward.
Why?
Lordship, the jurisdiction lordship,
Okay.
they have to approach the court of first instance, that is the CAT. Central Administrative Tribunal lordship, on the last day.
My lord, they have raised the question, but there is no impugn order any as such, my lord.
Lordship,
They have not passed any order to allowing or rejecting me, my lord. They were just sitting over the matter. In fact, your lordship will find page 57 and Annexure 7, my lord. Lordship will find. This is in communication of 28/7/2023, much after that criminal trial, my lord. This is an order passed by the Bharat Sanchar Nigam Limited, subject granting of TSL status to the petitioner with respect to the Honorable Guwahati High Court order dated so-and-so, passed in so-and-so, and order dated 38/2017, passed in the WPC number so-and-so. In pursuance to the BSNL Corporate Office letter so-and-so dated so-and-so, letter of the CGMT Assam Telecom Circle Guwahati placed under reference 1 and 2, Honorable Guwahati High Court order dated 15/6/2017, passed in so-and-so, and order dated 38/2017, passed in so-and-so. The Honorable Supreme Court judgment order dated 29/3/2023 of dismissal of the SLP filed by BSNL Authority, my lord, at the Assam Circle. The subject cited above, the under mentioned 98 numbers of casual laborers are hereby conferred temporary status provisionally under the Casual Laborers Grant of Temporary Status and Regulation Scheme, with effect from 27/5/1996 on the date of joining pursuant to letter number so-and-so. And your lordship will find at page 59 my name at serial number 6, my lord. If their stand is that, my lord, they would not have been regularized, my lord. Thereafter, your lordship will find replying to my RTI application, my lord, at page 71, my lord. This is in communication by the Administration Office of the GM BSNL Test Formulas.
With reference to the subject cited above, it is to inform you that your case is that is reinstated to the original post as TSM at Mongoldoy under SDPOP BSNL. Mongoldoy is forward to the Circle Office Guwahati. Then your lordship will find page 72, my lord. This is a communication by the Assistant General Manager to the Chief General Manager regarding re-engagement of casual labor TSM after disengagement terminated due to arrest of police under criminal case so Mohammed Chattar has been the petitioner. The undersigned is directed to refer to your letter dated so on the subject matter above. In order to enable the office to further course of action, it is requested to inform whether the judgment is that is the criminal case, my lord. In criminal case number so was challenged by the state of Assam in higher court or as early as possible. There is no appeal filed, my lord. Your lordship will find the next page, my lord. They have contemplated the proceedings to reinstate me, but that logical conclusion has not been arrived, my lord. Now, there is no such order to challenge before the court, my lord. Thus, they are sitting over the matter, my lord, not allowed to join me. And there is Ketana judgment of this Honorable Supreme Court stating that the alternative remedy, my lord, this is not an absolute bar, my lord.
No, that's all right, but are you interested to file your affidavit?
Let them file the affidavit, let the question will be open, my lord, the maintainability, my lord. Otherwise, my lord.
Otherwise, lordship, similar matter were remanded to the CAT lordship.
But there is no order against me, my lord.
No, you file your affidavit first. Thereafter, we will see.
Yes,
If
sir.
necessary, we will remand the matter. Otherwise, we will adjudicate the issue. Heard Mr. Hazarika, Learned Counsel for the petition. Mr.
P. Hazarika, on behalf of Mr. B. Pathak.
P. Hazarika, Learned Counsel, appearing on behalf of Mr. B. Pathak, Learned Standing Counsel for the BSNL. And Mr. A.K. Dotto, Learned Counsel for the respondent number 1. The Learned Counsel for the respondent number 226 has raised objection regarding the maintainability of this petition. And he submits that at first the petitioner ought to have challenged the matter before the CAT, but without doing so, he approached this court directly under Article 226 of the Constitution of India. However, he submits that he may be granted some time to file affidavit in opposition, bringing on record the stand of the department, being respondent number 226. There is allowed recital is a matter after vacation.
My lord, that may be fixed after BU vacation.
After BU.
Any day, sir.
28-1.
28. Public.
Item 24. 24.
May his worship, my lord, here the petitioner was dismissed from service on the charge of a partially proof charge, my lord. A departmental proceeding was initiated against the petitioner. Two charges has been framed against the petitioner. The first charge has been partially proved, and the second charge has not been proved at all. Here, the petitioner was dismissed from service only on the charge which has been only partially proved, and which is dismissal from service on a mere allegation is a total failure on the part of the administrator.
Where is your affidavit?
Taking one more opportunity to file it. 2 weeks, that in 2 weeks, my lord will file.
But till now, how many opportunities you have availed?
In the last 3 occasions, my lord.
Heard Miss
P. Bapangla.
Learned Counsel for the petitioner and Mr.
I got no money.
Learned Counsel for the respondent. Mr. Borthakur submits that he may be granted last opportunity to file the affidavit in opposition. We are allowed in the event of failing to file affidavit in opposition to proceed to hear and dispose of the matter without the on the basis of materials placed on record without the affidavit of the respondent. List the matter after reopening.
Item 25.
Are you? May I please, Lordship? Lordship, this is a matter where I am an assistant jailer for the last 14 years. So this, I had applied for the NIA, I had set for the exams. I had cleared the exams and I was allowed to join the NIA. But after some time, actually, one DP was conducted against me. And my allegation is on the parda of the DP. Without letting me know, I was cancelled to join, to go on deputation to the NIA. My basic concept is actually this thing is, I can bifurcate it in three parts actually. One is which begin from 5/8/2024 to 15/2/2025. Herein, I was allowed to sit for the exams. I was allowed to appear for the Viva every day, and I was selected. All the papers were in favor of me. I was allowed to go, and everything was done till 15/2/2025. And from 15/2/2025 to 18/5/2025, one matter happened in our jail actually, for which the DP was conducted upon me. And after this 21/5/2025 till as of now, I am serving as a senior assistant jailer at Mongoldo PS jail actually. Now, coming to this, what happened is actually the DP, in my read actually, I have not stressed what happened over here. I have only asked this honorable court that the results of the inquiry officer was supposed to be given on 18/5/2025. Till 18/5/2025, there was no inquiry report given to me, nothing, and I consider that it has been favorably gone in favor of me. Now, just coming to what had happened on this thing actually, two convicts were over detained for a period of 50 years, for a period of 50 days. I was the convict in charge at that time. Now, the thing is that as per the jail manual, I am under the direct guardianship of the jailer, and the jailer is under the direct guardianship of the superintendent of the jail. So whatever is I have to do, this under the jail manual actually, everything has to be reported and everything goes through this one. Now, in my case actually, after this convict was over detained unknowingly for a period of 50 days actually, some news items came in the newspapers and in the TV media. Then only all the people came to know. Now, in this thing actually, this DP is also a bit of thing that which happened 3 times actually. First, the superintendent of the jail, on 15/2/2025, issued me a show cause notice on why it happened and why it went wrong. Very next day, I gave the reply. Then, departmental inquiry was also done on 17/2/2025, which report was also given, stating that I and the superintendent of jails are at fault actually, but nothing course of punishment or action was again given. Again, the same procedure, the same cause list, the same cause of action, the IG issued the show cause notice on the same point actually on 4/4/2025, wherein one inquiry officer was asked to inquire the thing. The inquiry officer gave 3/5/2025 that the inquiry will be conducted on that day. And on
No,
the
no, you tell me before imposing punishment whether the inquiry report was furnished to you.
there was no punishment as of the still as of right now. There was nothing punishment. But the three so-called notice which they have given to me, which I have replied, there were till now.
No, no, whether departmental proceeding was initiated against you.
Departmental, yes, departmental
Initiated.
proceedings was initiated against me.
Hmm.
And I said on
Whether
it,
the
and
inquiry report was furnished by the
no,
inquiry authority.
No, that's what. The inquiry report, what went? Till now, before filing this one, we were not known. And the thing is that my deputation was cancelled. That I came to know in the month of July. Without being informed me, they had cancelled it. Without letting me know. I am the one person, but without letting. Now the thing is that why it came into this picture, because on some 12/6 actually, 12/6, I got a call from NIA. Ki, what is the status of your application? Then I wrote a letter to the IG through the superintendent of jail, Mongoldoy. Then
Okay. Yes, so what is the status of the disciplinary proceeding?
We have filed the affidavit, Lordship. The status of the DP, it is still pending, Lordship, because after the inquiry, the inquiry for the say.
When the inquiry report was submitted?
Lordship, on that, inquiry. Actually, what has been, Lordship, may kindly see para number 11.
No, you first answer my query.
The inquiry officer was directed to submit the inquiry report within 15 days. The inquiry officer, Sri Bhavan Chakraborty, requested for giving more time for completion of the inquiry. Moreover, it was evident by the inquiry officer whether any complaint is received from the release publics or other relatives for the avoid defense of the some necessary justice. Although no such complaint has been received till date today. In the meantime, the petitioner Susmita Panta was transferred from central jail to Guwahati jail. This was obtained as the inquiry has not been completed at the time of transfer. The petitioner was not furnished the inquiry report. That is the thing. As per the affidavit, when we have filed, the inquiry was not been completed for furnishing the inquiry report, because Lordship, not only him, there were other two inmates also, Lordship, who has now extra of 50 days. We have to give notice to other person also. The whole thing has to be first to complete, Lordship. Accordingly, Lordship, if the inquiry report it is because Lordship, if the inquiry report is out, then don't definitely serve him before completion of the before passing and before the hearing, Lordship, of the DP.
No, now he is in which department? In the
He is serving as Taylor in
She.
before.
So why the inquiry? Why the inquiry report could not be furnished to her then?
Because while filing the affidavit, inquiry was not been completed. That was the inquiry report was not been. Right, like it was still pending, Lordship. That time, I don't know about today because this affidavit was filed just some days back. 2 days, I think. That's the second week of December. 1/12 it was in file, 1st of December. So I don't know the today's status of the inquiries, but at that time, just before 2 weeks, it was not been completed. And otherwise, in regard.
When did you file your affidavit?
1/12.
1/12.
1 December, 1st December. Yes, yeah, 2 weeks back.
May I please, Your Honor?
Second, in regard to violation of that necessary has been violated. We have stated in our affidavit that Susmita Pathak was given reasonable opportunity to know the charges which was mentioned in the article issued to her by office letter submission letter for the device of the inspector general.
Okay, you obtain the up-to-date status of the disciplinary proceeding? No, you have already submitted that inquiry completed. The report could not be furnished because he is in the Mongoldoy.
What I have submitted was it, as the inquiry has not been completed at the time of transfer, the petitioner was not furnished with the inquiry report, para number 11. So, while filing the affidavit, it is the stage was it is the stage. So today, whether it has been completed or not, I have to take the updated instructions.
May I please, your
I
lordship?
don't think also in 2 weeks, something great has happened.
Lordship, this,
So we would like to have some more time also, because I don't think also within a period of 2 weeks. Because the whole inquiry consists of cross-examination of witness, parties are required to file their own objection. So I think it will take more than 2 weeks time. It's still pending, and I don't think also in just in a moment of 2 weeks, something great will happen. So, and his basic prayer is lordship, if lordship see the prayer number 2 of the petition, cancellation of deputation to as investigation to the NI. Because the lordship, the DP is pending, and there will be charges against him that in his presence, 2 intimates has to serve extra 50 days more. So that is the only thing, lordship, and basically, lordship, ultimately in the defeat, the punishment is not being given, but that is just only supposed to go as a deputation officer, but he was, but instead of that, he was been transferred from Guwahati jail to Mongoldo jail. See to Guwahati jail to Mongoldo jail. That is the thing, lordship. I don't think also there is any infirmity here, because there is nothing that nationality has been violated in this case.
No. Here the allegation is that she is not allowed to cross-examine the witnesses.
No, that the petitioner lordship may kindly say para number 12 of the affidavit. Petitioner got sufficient time for inspection.
No, that
of
is your
eligible-
statement.
Yes, affidavit in opposition, para number 12. The reply to what has been.
Better you do one thing, you produce the relevant record before this court. We'll see. Disciplinary proceeding.
One thing also I just have to pay loss. If I get the original record of the DP has to.
No, if it is completed.
may I please, your lordship? I just wanted to say one thing actually. In specific in the letter which the IG mentioned to the inquiry officer, it was clearly stated that you have to give the reply inquiry report within a span of 15 days. Clearly mentioned. It is here only. I have enclosed.
Maybe due to
Yeah,
current
that-
reason, he may not be able to complete the same.
Because yes.
That your lordship, whatever you say, it is true. I maybe not at them, but the reasons why it is not been completed is also absurd.
No, because lordship, we have to give notice to other parties also. They have to come. They are also required to participate in the proceeding, lordship. It is not only that he and me, we are both are participating in the proceeding. There are other parties too. You have to get.
No, other parties are.
I think that. In fact, the other.
No.
The other listed witnesses.
In a disciplinary proceeding, who are the party?
Basically, the other listed witnesses, lordship. Other authorities of police, lordship. Other authority, because lordship, he was only because lordship, during her tenure incident, actually, she was in search process. She was only taking the search of another jailor while being as assistant jailor in Guwahati. So other the position of other witnesses are also
Required, but you are not aware of the present status of the site proceeding.
Then I can get the record, lordship. Everything will be clear. But if I get the record, lordship, it will be stay for some time, and he will not be benefited from that. If I get the record, if he cannot go ahead, lordship, and by anyway, he will not be benefited because it has to be black or white, lordship.
Okay.
Lordship, may I just say one thing? The affidavit in opposition which they have filed actually, it has been filed by one Deputy Inspector General of Prison Headquarters. Okay, he said that Assam, the petitioner has arraigned the Inspector General of Police Assam Khanapara Guwahati 22 as aspirant number 2 in this case, and I have been authorized by the Inspector General of Prisons. In here, with my limited knowledge, there is no such authority letter which has been enclosed so that he can depose or he can sign on this affidavit.
It may be in the file.
Lordship,
It may be in the file.
This is deponent deputy IC of prisons, Gautam Bora. उसमें 46 से पेज नंबर 72.
You obtain
Signatory है,
you
deputy IC
obtain
of prisons.
up to date status of the disciplinary proceeding initiated against her.
No, sir, I can get the updated stuff.
Okay.
That-
Mr. Sururi has nothing to do here.
Huh?
I'll just point out one document from my academic, at page 81.
Yes.
She was selected, but your lordship will see para 3.
Hmm.
It is once again requested to release the above mentioned official with the direction to report to the DIG administrator by headquarters Delhi at an early date provided that she is clear from disciplinary vigilance and her integrity may also be certified. So once DP is processing action, perhaps property is that they are not released. Otherwise, there is no other prayer against any law.
What my land, this holding, this, if you look at my. What my land finance said actually in the page number 81. This letter was on 7th February 2025. At that time, selection, government approval, my will, all done, all completed, and I have annexed all the, my approvals notice over here. This letter is of 7/5, yeah. That's what I want.
In any case, lordship, if there is a vigilance center, the petition
Cannot be allowed. Okay.
and perhaps for that reason, she has not been released. The state authorities have. been done, lordship.
Heard, Mr. Mazumdar, learned counsel for the petitioner. Mr. RKD Sodhuri, learned Deputy Solicitor General of India for the respondent number 4. Mr. Learned counsel for the standing counsel for the respondent number 1, 2, and 3. Mr. Borwa submits that he is not aware of the latest status of the disciplinary proceeding that has been initiated against the petitioner. And he submits that he may be granted some time to obtain up-to-date instruction. They are allowed recess unless the matter immediately after reopening of the vacation.
Lordship, can we get a date if, can I get a date of this?
Ishod.
Pardon? 2? 21.
This January.
This January, okay.
26.
May please, your lordship. Shall kindly adjourn the matter for that day.
What?
The conducting counsel for the petition is suffering from illness. Lordship.
Okay. Will list after vacation?
After 4 weeks, lordship.
4 days.
4 weeks.
4 weeks. Okay. Mr. Heard, Mr. Your name, please?
T.T. Moni.
Learned counsel for the petitioner and Mr. Roy for CGC. Learned Roy. The Mr. S.S. Roy, learned CGC for the respondent. On the pair being made by learned counsel for the petitioner, the matter stands adjourned to be listed after 4 weeks.
Published.
Supplementary days, item number 52.
Yes, Mr. Lordship, here, at the last order, Lordship, direction was, there is a high Lordship, containing ASL, SLC for Lordship. Actually, mixed. I think, paying for the competition Friday, 19th of December.
Next Friday. Okay, none appears for the petitioner on call. However, Ms. S. Kumar, learned standing counsel for the respondent in Elementary Education Department, and Mr. You are appearing for
5, 6, and 7.
5, 6, and 7. Your name, please? K.U. Ahmed, learned counsel for the respondent number 5, 6, and 7. Present. Ms. Moore submits that she may be granted some time to produce the resolution of the minutes of the meeting of the DLC and SLC. They are allowed. List the matter after on Friday. Next Friday. In the event of subsequent non-representation of the petitioner, appropriate orders shall follow.
Lordship, 52, no? 52. I'm for the petitioner.
You are for the petitioner.
Lordship.
When
But
the SLC resolution and the DLC resolution are not made available.
direction is
today.
given to produce the document.
Yes. Next Friday.
Right.
For orders item number 27 and 28.
Also, we have 27 and 28, that the general group appear earlier also, the are good for around additional activity also. So when the madam is sitting in another district, we are.
When?
Advocate General next week, so far,
Next week is holiday.
No, Malad, the question is, I think the Advocate General as such has not appeared here. He may be in person. For the contenders, he may have appeared. The whole difficulty is here. Lordship may recollect. These persons, these petitioners in the writ petition, they were asked to be taken into service after this completing the selection process pursuant to the decision of the division bench affirmed by the Apex Court in 2022 against 2022 recruitment. Now they are raising a question of those verification of records regarding people NIOS 18 months DLed. Issue would be whether that can at all be raised here. That is one part. Number two, Lordship may recollect some of them, the others who had 187 DLed from the state itself. They have been shown as appointed. Lordship may recollect the director was asked to appear in person with the secretary. And they gave a commitment, yes, it will be complied. They have issued certain appointment letters to some of them. 187 candidates. And they have joined, but they have not, in October, but they have not been paid a single farthing till today. Single penny. Not a penny has been paid to them. So this is how, just to show on record that yes, you are appointed. And when they approach the director. And when they go to director. They have said. Unfortunately, director's reply is, as reported to us, that we have been asked to appoint you, not to pay salary. That's how the situation is. They have taken it otherwise. Yes. That because you are going to court, making us party in the case. Wait, see what happens. This is very unfortunate. So Lordship may. Meanwhile, let me be taken up after 2 days. I have no objection if he has personal difficulty. Mr. Foike has personal difficulties. But let them ensure why they have not been paid. Whether that amounts to compliance of the order of this honorable court. Therefore, why not those in respect of which the appointment letters were issued, why not they have been paid into the single penny? Or is the director will be present? Or otherwise that.
In this contempt proceeding, we can look into that aspect, non-payment of salary.
Let
That is a separate cause of action.
Sorry?
That is a separate cause of action.
Let in one go, yes. Yes. But I am raising the issue because they have given the appointment. Appointment means what? Mere issuing a letter is not enough. Appointment means you give them posting, you allow them to work and pay. That's complete.
But whether you have filed any affidavit to that regard before this court in
We
this
didn't.
proceeding?
We have filed a reply. We have filed a reply here against their contention.
No, regarding non-payment of salary.
Non-payment of salary can affidavit. No, not it. I am just pointing out, Mala.
Okay.
So let them come
Mr.
up with
Datta, you
instruction.
obtain instruction of
Yes.
why the salary has not been paid to the
Why not?
person already appointed, person to order of this court.
Yeah. Maybe take it up Wednesday, my lord. Because
Not possible.
it
No,
will be
no,
nearing.
when your advocate general will be available.
After 2 days, he will, as I have been now instructed by the.
All right, on Thursday. Lordship will put it on Thursday.
Thursday then?
Yes.
No, better you do one thing, you obtain confirmation on which date he will be available, only then we will fix the date.
Lordship. And instruction lordship is required to when. the
Why salary has not been
Why
paid to
not
the
pay?
already appointed
Yeah.
candidates? Heard Mr. K. K. Monto, learned senior counsel assisted by Mr. M. Monto, learned counsel for the petitioner. And also heard Mr. B. Deka,
BM Decca.
B. M. Deka, learned counsel for the petitioner in contempt case number 699.
764.
764 of 2023. And also heard Mr. Dotto, learned counsel for the contempt. Mr. Dotto submits that the learned advocate general will appear in this matter and he is not available in the court today, and on such count he applies for listening the matter after 2 days. After 2 days, fair allowed. During the course of hearing, Mr. K. K. Monto, learned senior counsel for the petitioner in contempt case number 699 of 2023 submits that some of the petitioners have already been appointed by the contemnors in the month of October, and they have not been paid salary till date. Accordingly, Mr. Dotto is directed to obtain instruction from the contemnor as to why salary has not been paid to the candidates who have already been appointed pursuant to the direction issued by this court. Please, Wednesday or Thursday, you confirm this court?
Then number 29.
Please, the lordship. I have joined that application in the affidavit in opposition filed in my I. I have filed in.
When?
Your lordship, I have filed it on 2/12/2025, but I found it was not in the record, your lordship. It come up on any day after lordship, knowledge was in the records.
Vacation.
After vacation, petitioner is also not there.
Heard Mr. Sinha, learned counsel for the applicant.
I am for the private respondent number 4 as well as the applicant in the I.
None appears for the respondent, none appears for the opposite party. However, Mr. Sinha submits that the applicant has filed affidavit in the IA on 2nd of December 2025, but the same has not been taken with the record. And accordingly, he submits that the matter may be listed after the vacation, directing the real estate to take the affidavit filed by the applicant with the record. Fair allowed, recess shall list the matter immediately after reopening of the vacation. You can take it back.
Item 30. Maybe lordship. Lordship, we have received the affidavit filed by the respondent, my lord. My humble paper, we have your lordship, my lord, 10 days time may be given to respond to this.
They have filed affidavit.
Wait, my lord, we have received.
In the meantime, I want to file an additional affidavit to bring some documents.
Okay. Heard Mr. Ahmed, learned counsel for the petitioner. And also heard Mr. P. K. Bora, learned counsel for the contemnor. Mr. Ahmed submits that the contemnors have filed their affidavit and the petitioners want to file their rejoinder and price for granting 10 days time, they are allowed, recess shall list the matter immediately after reopening of the petition. Mr. Bora, learned counsel for the contemnor, also submits that he may be permitted to file one additional affidavit to bring on record some documents. They are allowed, recess shall list the matter after
Lordship,
reopening.
if they are going to file another additional affidavit, my lord, then, my lord, along with that affidavit, my lord, we may be allowed to file later on, my lord, after they are filing, my lord.
Let them first
Let
file
them-
the,
Yes,
thereafter we'll
then we
consider
can,
your
we
query.
can reply accordingly, my lord. 31 and 32.
Wait, please, this is for non-compliance of the judgment and order dated 26/9/2019, madam.
Who will appear?
The question, Lordship. His Eminence.
After some.
At two. Bacha.
33.
May I please, Lord? As per ordered last occasion, Lordship, as in last occasion, the service along with pension papers, Lordship, was sent to respondent number 1 by the respondent number 4, Lordship. Today, Lordship, counsel for respondent number 1 is to apprise the court whether they have received, he has received the documents or not.
Yes, who is for the contender?
Lordship, respondent number 1 is Register of Assam University, Lordship.
Assam University Standing Council. Mr. Kyle appears?
Yes, Lordship. He appeared, Lordship, earlier.
I'm referring for the respondent of one year. For Assam University. Lordship, in this matter, the inspector of school has submitted us the registered book, but regarding the pro data past service benefit, they have not submitted any documents. We have also prepared a letter to the inspector of school that will be furnished to them regarding the documents which is required for the past service benefit, because it will be difficult for us to calculate how much pension has to be given to the petitioner in this case.
Lordship, in the letter, order itself reflected that it's a service book and everything details for pro rata pension, Lordship, submitted to them, Lordship.
Have you received the service book?
Service book here.
Then,
But regarding the past service benefit, we have not received anything there.
no,
Lordship, it's difficult
that
for us.
past service rendered by her will be available in the service
But,
book.
that has not been there.
Why?
We have been instructed by the department, by the university. Yes.
Yes, they are supposed to close with that. We have already submitted that proposal.
No, that's all right. His contention is that along with service book, no service particulars have been forwarded. So therefore, they are not in a position to calculate the pension amount.
Letter has been prepared, it has been, will be issued to the inspector of school within a day or two.
Sister, you ensure transmission of all the documents relating to her service to the Assam University.
Yes. I will inspect it.
No, now I don't know whether after submission of this service book, any other service particulars are available with the department or not.
Original service book has already been submitted. Yeah, nothing remains left. They have to decide upon that, Lordship, on the basis of the service.
Lordship, 5 years, Lordship. 5 years, this contribution is pending before this court, Lordship.
Did on the petitioner, Lord, that blame he cannot give, Lordship.
Lordship, my
Because
lord.
He didn't accept that pro rata pension. He didn't sign that required document. He took 1.5 years to sign this document. That blame of he should give to the respondents only.
Lordship,
No, that's all right. And now you have forwarded all the 11 particulars.
What is the pension return date? Pension say it should go to the Assam University. So we have submitted the original documents to the department, to the Assam University. So on the basis of-
Okay, let us do one thing. Let us fix it on Friday. In the meantime, you produce the letter before
Lordship.
this court. Only
Lordship.
then we can ascertain why the pension could not be could not be paid to her. Heard, Mr.
PK, that's
Learned Counsel for the petitioner. Then Mr.
KJ on behalf of Mr.
Learned Counsel appearing on behalf of Mr. S. A. Kayal, Learned Standing Counsel for the Assam University. Contender number
1.
contender number 1 and Mr. SMT Sistik for that contender number
226, Lordship.
226. Mr. Zain, Learned Counsel appearing on behalf of Mr. S. C. Kayal, Learned Standing Learned Counsel for the contender apprise this court, contender number 1 apprise this court that some of the service particulars of the petitioner has not been forwarded by the contender number 2, 3, and 4, 2, 3, 4, and 6 to the Assam University, for which the pension amount which the petitioner herein is entitled to could not be ascertained. And as such, one letter is being prepared to the contender number 2226 to forward all the particulars, service particulars of the petitioner to the Assam University. And he pressed for listing the matter on Friday so as to enable him to produce the said letter before this court. They are allowed recess and list the matter on Friday.
Yes, may I, the inspector school on this April 11/25 to the register in Assam University. I have the honor to submit here with the original submit book, one number, along with the pension papers and other relevant documents. So he has submitted, I think, all the documents of it.
Okay, but first let us ascertain from him what are the documents they are praying for.
34.
May I please, Your Lordship? Lordship, this contempt application has been preferred against the judgment and order dated 19/10/23, Your Lordship. Lordship, there were basically three reliefs, Lordship. Firstly, I was, Lordship, if Your Lordship may peruse page number 39, Your Lordship. But out of three reliefs, Lordship, I was reinstated and I've been paid the current salary, Lordship. However, the area salary is not being paid, Lordship. Area statement has already placed before this honorable court. That is on record, Lordship. And
What is the amount?
Lordship, amount is 18,41,776. That is on record, Lordship. Area statement has been produced.
Mr. Das, why the
18,41
amount has not been paid?
Last to last occasion, I think, we have placed one is, instruction that the service book of the petitioner actually, misplaced by the college authority. That's why we asked the college authority to reconstruct and send some documents that has been received by the, as per my verbal instruction, that has been received by the director, the college authority has sent. It is under verification.
Okay.
So kindly, give me.
Order dated 1 September 2015.
2 weeks time,
2000.
enough time, I think.
Okay. 2 weeks time. Okay, after vacation?
Yes, Lordship, we may, Lordship will only fix a date, Your Lordship.
Okay. Heard, Mr.
H. Mozumdar, Your Lordship.
Learned counsel for the petitioner and Mr. Das, learned counsel for the contender. Mr. Das submits that the arrear salary of the petitioner could not be paid due to missing of the service book of the petitioner. And accordingly, the college authority was directed to reconstruct the service book of the petitioner, and the same has been received by the contender,
Director.
that is Director Higher Education, and it is being verified. And he pressed for granting 2 weeks time to release the arrear salary of the petitioner.
If Your Lordship may kindly record the amount, Your Lordship, this is already on record, Lordship. 18,41,776, Your Lordship.
They will verify it.
2 weeks for updated instruction.
No, you comply with the order.
No, that is with compliance of this honorable court only. My lord, actually, they say there was 2 weeks for placing updated instruction or compliance with that.
Lordship, it is a judgment and order of Lordship 2023, Your Lordship.
Okay, up to date instruction as well as compliance order. List on.
22nd January.
Quickly, Your Lordship.
10:35.
May it please your lordship. My lord, this matter pertains to my lord family pension. My lord, the petitioner husband, my lord, was appointed in the year 1987, my lord, as a Khalasi, my lord, in the respondent department. Thereafter, in the year 2005, my lord, he was regularized, my lord, at page 24.
No, this matter is listed under the order column.
My lord, only thing is that already 2 person has been, my lord, from the list, my lord. Already our High Court has passed order, my lord. Similar, my lord, order. If your lordship come to page number
No,
54,
no,
my
you
lord.
see, today this matter is listed under the order column.
Yes.
Why? Whether all the parties are before the court.
Yes, my lord. They have already, my lord, all the government party and appeared, my lord. Already, my lord, at page 54, your lordship.
Who is the standing counsel for PAC department? Mr. B. Gogoi? B. Gogoi or D. Gogoi? D.
Oh, these are the-
Is he present in the court today?
Yes, he was. I will inform you.
Okay, at 2 o'clock then.
Problem here is, Manoj, his regularization order was subsequently cancelled. Now we are challenging the cancellation order. So to get any benefit, my lord, your lordship will have to interfere with the cancellation order. So that's the main problem out here. That is why, my lord, the-
You are for the AG.
And for the, that is why the pension papers have not been forwarded to the office of the AG. It's only the regularized employees who are entitled to the benefit of pension, my lord. Here, in this case, the person concerned, it's an admitted fact, his regularization order was cancelled in the year 2006 itself. Now he's challenging the cancellation order, and if your lordship interferes with that, my lord, then only his pension paper. And it's not that single out.
My lord, already, my lord, by those two orders, already that has been, my lord, decided by this honorable court. Yes, my lord, if your lordship go to the one judgment of Bijan Hafila, he's from the same list of, my lord, regulation. His pension has been regularized by this court, my lord. Similar, my lord, they have, my lord, at serial number, my lord, one is at serial number 22 and I am in the serial number 11.
Okay, let the counsel for the PSA department come. We'll hear him. Thereafter, we will pass order.
36 and 37.
At 2 p.m.
All right.
My lord, I have received the order of this pension, but the area salary has not been done yet. Today morning we have received.
Regarding area salary? No, no,
Order
regarding
for-
area salary.
Area salary has not.
Sometime means how many weeks? 3 weeks. Heard Mr. Purkaisto, learned counsel for the petitioner, and Mr. U. Sharma, learned counsel for the respondent, contender number 123, Mr. Soliha, for the respondent, contender number 4.
36.
During the course of deliberation, Mr. Purkaisto submits that the petitioner has received the pension payment order.
Yes, today.
Pension payment order, but the arrear amount of salary has not yet been received by him. Mr. Sharma, learned counsel for the contender number 123, submits that the contenders may be granted 3 weeks time to complete the entire process. And as the amount of rupees 3,81,100 has already been sanctioned by the contender. Accordingly, it is provided that rest shall list the matter after 3 weeks. In the meantime, Mr. Sharma shall ensure payment of the arrear salary to the petitioners and place the compliance order before this court.
It will be minus 4 weeks maximum.
It will come on 20.
During the.
No, the amount has already been sanctioned.
Yes.
Now what remains to do?
Some processing of the GR minus.
No, you expedite the process.
GR minus.
It may be on 29th.
I have new vacation also GR minus, so.
It may be on
Okay,
20
after 4 weeks. Let them complete the
It
process.
may be on 29th January, my lord. By this time, 4 weeks. will be
Okay,
over.
29 January.
Right.
Okay. We'll resume at 2.
Against a private, it is a writ against a private university. So our assertion primarily was that when a writ jurisdiction is called upon for a private university, there are two determining factors which we had taken from the case of Janet Jaipal versus SRM University. My colleague is there with a paper book for cases. Has my lord received the paper book?
Yes, yes.
Great. Yes, thank you. There, Janet Jaipal gave us two tests regarding the mandamus jurisdiction. One was whether the private entity performs a public function. And number two is whether a duty of the public law duty has been violated. Now, my lord will see I have attached 5 judgments. I'm going to, however, read out the relevant paragraphs of all these judgments. And since it is a settled sphere of law, most of the judgments overlap. They quote one another. So we have not taken the time of the court to add 100 judgments. Instead, we have given the most relevant ones. And if I may have your permission, I will take you through the relevant paragraphs of the judgments, my lord. May I take my lord's attention to page number 26 of the paper book?
Yes.
My lord, this is the paragraph in the judgment of Roy Chan Abraham versus State of Uttar Pradesh and others, which was upheld by the Supreme Court of India. I'm quoting from here because this also quotes Jaipal and explains the twin test with a lot of detail. So this is paragraph 31, which says the susceptibility to judicial review and approach solely based on the source of public authority's power came to be considered too restrictive. The claim for judicial review has gradually shifted to a decision action or failure to act in relation to the exercise of a public function. The Supreme Court in Janet Jaipal versus SRM University, the one which I just quoted the approval following extract from decision of an English court. The extract is this: in determining whether the decisions of a particular body were subject to judicial review, the court was not confined to considering the source of the body's powers and duties, but could also look to their nature. Accordingly, if duty imposed on a body, whether expressly or by implication, was a public duty and the body was exercising public law functions, the court had jurisdiction to entertain an application for judicial review of that body's decisions. Now, the judgment further goes and examines various other judgments, which basically reiterates the same. May I now draw my lord's attention to page number 28 of the paper book.
Yes.
Now the question is, does a private university discharge a public function? That's the first test that we have to satisfy. So here is the discussion regarding the same. Even if it is paragraph 38, my lord. Even if it is assumed that an education institution is imparting public duty, the act complaint must have direct nexus with the discharge of public duty. It is undisputedly a public law action which confers a right upon the aggrieved to invoke extraordinary writ jurisdiction under 226 article for a prerogative writ. Individual wrongs or breach of mutual contracts without having any public element as integral part cannot be rectified through petition under 226. Wherever courts have intervened in exercise of jurisdiction under 226 article, either service conditions were regulated by statutory provisions or the employer had the status of state within the expansive definition under Article 12, or it was found that the action complained of as a public law element. We accordingly hold, this is paragraph 39, that a private body, though not a state, but performing private duty, is amenable to writ jurisdiction under Article 226. Whether a writ would lie on behalf.
Madam, you see, the middle of the paragraph number 38, where it is stated that individual wrongs or
Right.
breach of mutual contracts without having any public element, as
Right.
as its integral part cannot be rectified through petition under Article 226.
Yes, my lord.
Is it the dispute in this present petition, is it not between the authority and the private individual?
My lord,
Where is
this
the
is
public element here?
the public element here is the violation of the UGC norms and the UGC laws. And this same judgment goes on to explain that how the violation of UGC laws and even government pay scale is a public function, my lord. If I may draw your attention to paragraph.
Whether the UGC norms deal with dismissal or termination of service of a private of a teacher.
It is not
private
it is
college,
not-
private university.
My lord, it is, yes, it does. It is not about termination. It is about termination on account of misconduct. That is one. And the second thing is regarding the PhD standards. Because the professor is a PhD guide and she has been terminated regarding the dispute which was raised by a student. And the PhD grievance redressal is a procedure that is entirely governed by UGC norms, which is the, I will tell you, the University Grants Commission Redressal of Grievances of Students Regulations of 2023, my lord.
Okay, madam, let us do one thing. Let notice be issued at this stage, and after hearing the other side, we will consider your interim PR.
My lord, much obliged. Can I have a fixed date, my lord, so that I can make my.
But the question is whether you will be able to serve the notice upon the private respondent.
If we
within
can
the
have Dasti, if we can have the permission for
Okay.
Dasti, we'll do that.
heard Miss Chatterjee, Learned Counsel for the. You are Miss Chatterjee,
Yes, I'm
Learned
Ujjaini
Counsel for the
Chatterjee.
petitioner, and also no petitioner. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order. Challenge the termination order dated 25/10/2025, and also prayed for issuing direction to the respondent university to reinstate the petitioner with continuity of service, and also to direct the respondent university to release all salary, dues, arrear, and consequential benefit with interest. Where is the petition and the documents plus on record? Let notice be issued to the respondent, returnable in 2 weeks. Should be taken by registered by registered post with ADN, also by usual process within a week from today. Additionally, Dusty service is also permitted. After effecting service by Dusty mode upon the respondent, the petitioner shall file one affidavit before this court. Since the respondent university is admittedly a private university, the maintainability of the present petition is kept open. Recess shall list the matter on 19 January.
Much obliged.
Obliged, my lord.
Item number 51, fixed at 2 p.m.
This case, Lordship, the first point I want to raise, Lordship, the interim order was passed on 22nd. This court has passed the interim order on 22nd. 22nd of August. And the governing body chairman has already taken serve on 28th of August. And he has started meeting, he has done everything, and Lordship, yeah, well, he has taken serve. This very, Lordship, for last 10 years, but nothing was done. In one meeting, this new chairman has done everything, Lordship. And this college, this person, the petitioner, Gary, he was earlier for 2 terms, he was chairman. At that time, there was no knock, nothing. And when he left, immediately knock came.
Mr. Sharma, you see whether there is any bar for claiming the third term.
No, there is no bar.
Then-
No bar. Only thing, Lordship, he is related to a political party. And
No, maybe, but in this petition, whether we will look into that aspect.
this is in the rules itself, it is there, Lordship, specifically. No, he cannot.
Hmm.
He cannot. And it's a nominated post, Lordship rule.
Hmm.
It's a nominated post, Lordship. There are many Supreme Court judgment, Lordship, on that, Lordship.
Hmm.
That no, let him start.
My lord is taking up the state
IA,
education application.
IA.
In that case, my learned respected senior minister.
Yes.
So Lordship, may please come to.
No, what do you want? You want the writ petition to be heard or the IA? Or both can be?
If Lordship will heard the IA, Lordship can dispose of the whole writ petition. There is nothing left. Lordship, the IA, I will annex everything.
No. By
and-
disposing of the IA, we cannot dispose of the writ petition. We have to dispose of the writ petition only, then the IA.
Lordship, I want a vacating of stay because what happened, Lordship, that is why I first pointed out. The stay order is of 22nd. And the new chairman
No,
has joined on.
Mr. Sharma, you tell me after vacation of the interim order, would you like to continue with the writ petition?
No, on basis of this writ petition.
Then let us finally dispose of this writ petition.
Yes, my lord. in
If
that
the
case-
parties
Yes,
have already filed their affidavit,
Well, the fact remains, my lord.
Everything is done.
everything is done.
That's it.
Okay, then let him argue first.
Yes.
My lord, I have may I kindly submit, my lord?
Hmm.
Now, my lord, in this matter, my lord, this is a matter pertaining to appointment of the petitioner as the president of the governing body. my lord. Now, the appointing authority or the nominating authority is the state government, my lord. Now, my learned senior friend appears for the college where I was appointed as the president by the state government. Now, my lords, for disposing of the entire writ petition, with all due respect, my lords, the government has to put up their stand, my lords. They have not yet filed their affidavit till date.
Okay.
Now, it cannot be disposed of without the
Yes,
government filing the
Mr. Das,
affidavit.
are you interested to file your affidavit here?
Because they have removed me, my lords.
Section not received.
My lord may take up the entire matter after vacation, my lord. Let them file the affidavit.
Then stay may be vacated now. See,
In that
they-
case, my
they
lord may
make
hear the
evidence
stay
time.
vacation application.
It's a black and white case.
In that case, my lord may hear the stay vacation application, subject to what?
The nomination only. It's a doctrine of pleasure will come, Lord. See, the government can appoint someone, government can send it. There is no point, Lord. Continue. What right he has, Lord, for filing a writ petition, Lord? What type of right? He was appointed as a chairman, he has sense now. He has not taken anything, he has not do anything for the college. And the person, he has joined on 28th of August, and he has completed everything, Lordship. And now, because of this stay order, Lordship, everything is halt. Lordship, may please come to page 26 of my IE. IA is 3569 of 2025. Lordship, may please come to page 26.
Yes.
Para 29. The presently, the concerned order is required to be vacated by the honorable court because the ZB meeting under the presidency of the Pokuma opposite party number 6 is required urgently convened for the following reason. Promotion of teaching and non-teaching staff, interview for vacant teaching and non-teaching posts, service book verification and retired principal in charge of so-and-so, approval of formal research council, approval of promotion of post of third grade employee, approval for establishment of video conferencing room for conducting international seminar, approval of formation of finance committee, and the applicant has received government clearance to acquire 125 acres of land for the expansion of the college, thus requiring an urgent GB meeting to take key decision for planning. However, owing to the above mentioned circumstances surrounded by the sponsor. So, Lordship, the Pokuma defendant number 6, he has already joined on 28th of August. And Lordship, I have given everything, Lordship, and black and white, it is complete. After the governing body, he took steps, it is done. Because 1 month after only notice was served. That too after he took charge, Lordship. Indeed, it was not placed before this court. When the stay order was taken, stay order was of 22nd. And he took charge on 28th of August. So this stay order, before this stay order, he joined. And he started working, Lordship. And the removal is of June, Lordship. And stay taken in the month of August. 22nd of August. And Lordship, what is the explanation that he do not know? He came to know about it by WhatsApp message. That is the, in the writ petition, that is only one paragraph he has stated that I came to know by a WhatsApp message on such and such. And then after receipt of WhatsApp message, that is after 20 days, he filed the writ petition, Lordship. And then took this stay order. Lordship, there is nothing. Let the governing body function, because the governing body has already started functioning when this stay order was passed. And let the college go ahead, Lordship, because Lordship, he has not taken, after he is taken charge, there is no governing body meeting, Lordship. I have given all the documents. And Lordship, for a moment, Lordship, may please come to page 116. If after all these allegations, Lordship, one person can continue, this is unfortunate, Lordship. A public institution is suffering. Please, page 116. Lordship, may I read in the vernacular, because the Lordship in the translation, Lordship will not get that. Because this is a memorandum to this education minister, page 116 of the IA. Dated 17/3/25. মাননীয় শিক্ষামন্ত্রী মহোদয় অসম চৰকাৰ ডিমৰীয়া মহাবিদ্যালয় পৰিচালনা সমিতিৰ সভাপতি অপসাৰণ প্ৰসংগত ৰাজহুৱা অভিযোগ মহাশয় কামৰূপ মহানগৰ জনজাতীয় অধ্যুষিত and that too is a tribal area, tribal dominated area. অগ্ৰণী উচ্চ শিক্ষা প্ৰতিষ্ঠানৰ ডিমৰীয়া মহাবিদ্যালয়ৰ কেইজনমান অশিক্ষিত তথা দুৰ্দশী সহালোকৰ সপোনৰ ফচল অঞ্চলটোৰ মৰম আৰু আশীৰ্বাদ লৈ অনুষ্ঠানটোৱে 2010 চনতে ঐতিহাসিক কটন মহাবিদ্যালয় সমকক্ষ হৈ নাকৰ মূল্যায়নৰ A গ্ৰেড পাবলৈ সক্ষম হোৱাৰ উপৰিও কলেজ ফৰ পটেনচিয়েল অফ এক্সিলেন্সৰ মৰ্যাদা লাভ কৰাৰ পিছতো যোৱা প্ৰায় এটা দশক অন্ধকাৰত নিমজ্জিত হৈ আছিল সৌভাগ্যক্ৰমে যোৱা প্ৰায় 1.5 বছৰ আগতে আমাৰ দূৰদৰ্শী মুখ্যমন্ত্ৰী মহোদয়ৰ নিৰ্দেশ আৰু প্ৰত্যক্ষ তৎপৰতাত ৰাইজৰ সপোন আৰু আকাংক্ষাক প্ৰাধান্য দি আপোনাৰ বিভাগে যি সময় উপযোগী ব্যৱস্থা গ্ৰহণ কৰিলে তাৰে ফলশ্ৰুতিত অনুষ্ঠানখনে পুনৰুত্থানৰ বাট পেলাইছে একাংশ নিষ্ঠাবান যি সময় উপযোগী ব্যৱস্থা গ্ৰহণ তাৰে একাংশ নিষ্ঠাবান আত্মত্যাগী শিক্ষকৰ আহোম পৰমাৰ্থ কম দিনতে মহাবিদ্যালয়খনে স্বায়ত্ত শাসনৰ মৰ্যাদা লাভ কৰিবলৈ সক্ষম হৈছে আপোনাৰ বিভাগেও অনতিপলমে স্বায়ত্ত শাসন মহাবিদ্যালয়খনৰ বাবে এখন পৰিচালনা সমিতিৰ অনুমোদন জনাই মহাবিদ্যালয়খনে এই যাত্ৰাত পথ প্ৰদৰ্শক হোৱাৰ লগতে সহযাত্ৰী হৈ আছে কিন্তু মহাশয় ৰাইজে জানিব পাৰিছে যে মহাবিদ্যালয়খনৰ পৰিচালনা সমিতিৰ সভা সময়মতে অনুষ্ঠিত নোহোৱা বাবে স্বায়ত্ত শাসনৰ পৰীক্ষা সংক্ৰান্তীয় কেতবোৰ গুৰুত্বপূৰ্ণ সিদ্ধান্ত লোৱাত মহাবিদ্যালয় কৰ্তৃপক্ষ ব্যৰ্থ হৈছে যাৰ ফল ইতিমধ্যে অনুষ্ঠানটোৰ শিক্ষা নিচলা ছাত্ৰ ছাত্ৰীৰ ভুগিবলৈ আৰম্ভ হয় উল্লেখযোগ্য
যে আপনার বিভাগে অধ্যাপক কৃষ্ণগোপাল ভট্টাচার্যক পরিচালনা সমিতিৰ সভাপতি নিযুক্তি দিয়াৰ পিছত মহাবিদ্যালয় ভাৰপ্ৰাপ্ত অধ্যক্ষই প্ৰস্তাৱিত প্ৰথম সভাৰ বাবে সময় বিচাৰে যদিও তেওঁ ব্যক্তিগত আজোৱাত দেখুৱাই সেই সভাৰ তাৰিখ পিছুৱাই দিয়ে। অৱশেষত ভাৰপ্ৰাপ্ত অধ্যক্ষ নেৰানেপেৰা চেষ্টা আৰু সভাপতি কৃষ্ণগোপাল ভট্টাচাৰ্যৰ অনুমোদনত যোৱা 15/2/2025 তাৰিখে প্ৰথমখন পৰিচালনা সমিতিৰ সভাৰ দিন ধাৰ্য কৰা হয়। সেইমতে ভাৰপ্ৰাপ্ত অধ্যক্ষই পৰিচালনা সমিতিৰ সকলো সন্মানীয় সদস্যক আমন্ত্ৰণ জনোৱাৰ লগতে সকলো যাৱতীয় ব্যৱস্থা গ্ৰহণ কৰে। উক্ত দিনা সকলো সন্মানীয় সদস্য সময়মতে আহি সভাকক্ষত উপস্থিত হয় আৰু সভা আৰম্ভ কৰিবৰ বাবে পৰিচালনা সমিতিৰ সভাপতিলৈ আগ্ৰহেৰে ৰৈ থাকে। কিন্তু সভাপতি কৃষ্ণগোপাল ভট্টাচাৰ্যই মহোদয়ে আহি সভাকক্ষলৈ নগৈ অধ্যক্ষৰ কোঠাত বহি থাকে। ভাৰপ্ৰাপ্ত অধ্যক্ষৰ বাৰম্বাৰ অনুৰোধৰ পিছতো তেওঁ সভাগৃহলৈ নাযায় আৰু প্ৰায় 1.5 ঘণ্টা সময় সকলো সন্মানীয় সদস্যক অপেক্ষা কৰোৱাই মহাবিদ্যালয়খনৰ পৰা ওলাই যায়। আনকি পৰিচালনা সমিতিৰ কোনো সদস্যকে তেওঁ সৌজন্যমূলক মাত এষাৰো নলগায়। মহাশয়, এজন উচ্চ শিক্ষিত বিশ্ববিদ্যালয়ৰ অধ্যাপকৰ এনে আচৰণত আমাৰ দৰে সাধাৰণ ৰাইজ মৰ্মাহত হৈছো। লগতে আমাৰ শংকা হৈছে যে এনে আচৰণৰ অন্তৰালত নিশ্চয় আন কিবা অভিসন্ধি আছে, যিয়ে অদূৰ ভৱিষ্যতে অনুষ্ঠানটোৰ বিস্তৰ ক্ষতি কৰিব। তেওঁৰ বিপক্ষে থকা ৰাইজৰ আন কেইটামান অভিযোগ হৈছে: ক, অধ্যাপক কৃষ্ণগোপাল ভট্টাচাৰ্য এইবাৰৰ সৈতে তৃতীয়বাৰৰ বাবে ডিমৰীয়া মহাবিদ্যালয় পৰিচালনা সমিতিৰ সভাপতি নিৰ্বাচিত হৈছে। গতিকে তেওঁৰ পৰিৱৰ্তে এজন ইতিবাচক গতিশীল বিজ্ঞ লোকক সভাপতি নিৰ্বাচিত কৰিব লাগে। তেওঁ সভাপতি হৈ থকা দুটা কাৰ্যকালৰ 10 বছৰ সময়ত মহাবিদ্যালয়খনৰ উন্নতিমূলক কোনো ধৰণৰ কাম কাজ নকৰিলে, আনকি 10 বছৰ ধৰি নাকৰ মূল্যায়নো নকৰিলে। তেওঁৰ দ্বিতীয়টো কাৰ্যকালত সভাপতিজনক প্ৰত্যক্ষ হস্তক্ষেপত নীতি বহিৰ্ভূতভাৱে জ্যেষ্ঠতাৰ ভিত্তিত উপাধ্যক্ষ নিযুক্তি দিয়াৰ পৰিৱৰ্তে তেওঁৰ পচন্দৰ এজন অধ্যাপকক নিযুক্তি দিছিল। অসম চৰকাৰৰ বৰ্তমানৰ নীতি অনুসৰি কোনো ৰাজনৈতিক ব্যক্তিৰ অনুষ্ঠানৰ সভাপতিৰ আসনত নিযুক্তি দিয়া নহয়। এনে প্ৰেক্ষাপটত অসম জাতীয় পৰিষদৰ দৰে এজন ৰাজনৈতিক দলৰ সৈতে প্ৰত্যক্ষভাৱে জড়িত এজন ব্যক্তিক কিয় এখন উচ্চ শিক্ষা প্ৰতিষ্ঠানৰ সভাপতিৰ দায়িত্ব অৰ্পণ কৰিলে সেয়া ৰাইজৰ বাবে নুবুজা হাতৰ। Now,
No,
he-
Mr. Sharma, whether you have enclosed any document to show that the person concerned belongs to Jatiya Parishad?
Yes, yes. Lordship, in the writ petition, we have filed our affidavit in opposition law. Page 109 to page 127.
Because I have filed my objection to the IA, my lords. For the affidavit, I have not yet filed the affidavit in reply. I have filed the objection. I that no documents were appended, my lords, regarding that affiliation. to-
No, can we not go through the?
Yes, yes, of course, my
petition?
lords, but I didn't get the chance to reply. I'll file my written objection if required.
Where?
To the affidavit.
Long back, Lordship, it is not now, Lordship.
No,
it is long
no, my
back
lords,
we have filed.
the IA would have been taken up, my lords. They have filed an affidavit in opposition in the main case.
What he
Question.
thought, I do not know, Lordship.
Well, let- I'll-
We have filed an affidavit, Lordship. It is filed on.
No,
long
no,
back.
if you are not ready to argue the matter, why you are taking the time of the court?
My lords,
If you are not ready to argue the IA,
I'm ready to argue the IA. Yes, I'm ready to argue the IA.
then
But my lord-
where is the question of filing objection now?
No, 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 to the affidavit in opposition. They have filed an affidavit in opposition in the main case. To the IA, I have already filed my objection, my lord. It's on record.
It's filed long back, Lordship, November.
Yes, you are referring to page number?
Page 109, annexure 2 point. Page 109.
Yes.
It is in the Economic Time and it's a national newspaper, Lordship.
No, maybe, but whether this newspaper reporting can be taken into
I
account?
will go one by one. So not only this document.
No, whether do you have any membership document of that
No,
party?
membership is not required. The rule is something different, not the member. Affiliated. Not the membership. Not the membership.
You saw the relevant provision of the rules?
Yes, yes, look. I annexed that. Lordship, it is page 76 is started. Lordship. Lordship may please come to page 76. It started at page 73. Lordship may please come to page 73.
Yes.
76, Lordship get it.
Hmm.
Rule 3, subsection 3. The president of the governing bodies of the college shall be an eminent person from the field of education. He shall be non-political person. First word is he shall be non-political person. Then he should not have contested any election, including panchayat, municipality, local bodies election, or should not be an office bearer of any political party, or should not have any affiliation, membership to any political party.
Here, there is the word affiliation, membership to any political
He is
party.
the person, he has started the AJP, and so did Upindos.
No, do you have any membership document?
Yes, yes. No membership. Membership to he cannot be a member, Lordship. He is the organizer. He has first started at his BS Lordship, he started the AJP. That's the thing. He had the affiliation with political party, that's all. Membership is a different matter, so that is why there is an obligation, Lordship. Can be removed.
No, no.
And Lordship, not only that, Lordship, just if Lordship is page 76, Lordship.
Hmm.
Lordship may please come to 4.
Hmm.
After 3 days, 4.
Hmm.
He shall be appointed by the Director of Higher Education and shall have a term of 5 years. He shall, however, continue beyond his period till the successor is appointed. The director may, now Lordship will read the director may, however, remove him any time during the 5 years of his he to be recorded in writing. So
No,
director has this power.
that is not the question here. The question is whether he belongs to any political party or
Yes, he is a political party. man.
political
That's why
party.
I started with
But
109.
you have no document to show that he is member of that
No, he is
political
not a member. He is affiliated to a political party.
Hmm.
I'll show for me page 109. I have no say in my ear that he is a member of AJP.
Hmm.
He is associated, he affiliated.
Hmm.
He is the founder. He has given the call that we will start the so and so and being the founder, he is the founder of the Ahom Jatiyo Parishad.
Hmm.
And Lordship, now I can show some colored documents also.
No, in that
some
case,
people-
that political party might have been registered with the election commission of.
Yes, yes, yes.
Is it there?
Yeah.
Is it part of the record?
That they have registered or not. AJP. That we have not given the record to that. AJP is already Ahom Jatiyo Parishad, Nurinjyoti Gogoi and all, they have contested election also. In the name
No,
of-
that's all right, but to show that the petitioner is a member or organizer of that party,
He's an organizer, he's the founder. He is the founder, he is not a member, he is the founder. One should be a non-political party, Lordship.
no, that's all right. There is no doubt about it. But the question is, how do you satisfy the court?
Yes, I have so many documents.
No,
The
many
Lordship,
documents means that
even
this,
now, even one after another.
this paper cutting would not be sufficient to establish it.
On the social media here.
No,
of the
maybe.
Ahom Jatiyo Parishad, they have given his photographs is there.
Hmm.
What more is needed, Lordship? Photograph never tell a lie. He's there.
No,
standing
maybe.
on the-
Maybe there are some decision of the Supreme Court that this paper cutting could not be taken
Yes,
into
yes.
account.
Paper cutting?
Cannot be taken into account to arrive at such a finding that the person belongs to a political party or
Under
otherwise.
the Evidence Act, Lordship, I have to give the whole newspaper. That's the whole thing.
Hmm.
And I will bring the whole newspaper.
Hmm.
The paper cutting is a different matter. I have to give the whole newspaper.
This
And these are
paper,
the- these are
newspaper
the-
reporting also cannot be relied upon.
Lordship, then Lordship, for a time being, Lordship just forget it that he is a political member
Okay,
or not.
okay.
Lordship, forget it. This second limb of my argument. here.
Okay.
Then under 4, now Lordship may come to that.
Mm-hmm.
Now under 4 is 76.
Yes.
I'll now come to the second limb.
Mm-hmm.
If he is not a political person, let's forget. He is not a political person. Lordship, in Assam, I know that Krishna Gopal Vachaji is a political person and he is the founder of Ahom Jatiya Paribhar. That much I know. So let us forget that Krishna Gopal Bhattacharya has nothing to do with Assam Jatiya Paribhar.
Okay.
Let us forget for a moment. Page 76.
Mm.
4. The director may, however, remove him any time during the term of the 5 years, the result to be recorded in life. Anytime.
Mm.
He is a nominated member as a chairman. He was appointed, director wants, there are various complaints. Director wants that no, he will not continue, someone else will be there. Director is appointed, he has taken the charge. After
So,
that, someone has challenged that, and then there is a stay order of 22nd August. Before that, the person has joined on 28th of August. He started working. All the work is in there. So, what is his document? Page 42. What is his document? Let us see. In my IA, page 42. It is his document. Page 42.
Yes.
5. This is UGC guideline.
Mm.
It is their document.
Mm.
He relied on. Not my document, Lordship. So there is nothing to give a reply or the file an affidavit in reply or whatever.
Mm.
Let us see. What is the role of the state government? 5. To provide nominees on various statutory bodies of autonomous college.
Mm.
Page 45. Now, Lordship, please come to page 45. Lordship, get it. 5, Lordship is clear.
Mm.
12.3.
Mm.
Governing body. Page 45, Lordship.
Mm. That's all right, but you show me on what ground he has been removed by the director?
Lordship, there is a direct order from this court to produce the record. So I don't know why the record has not come. Lordship, may please come to place order dated 10/11/25. I'll only read one order. And there are many orders from this court to place the record. Lordship, may please come to 10/11/25 order of this court.
Yes.
And Mr. S. Sharma is started like that, Lordship. Lordship may come to the next page. There are 9, Lordship.
Yes.
As we are learned, counsel for the opposite party number 2, 3 and 4 shall produce the relevant file before this court on the next day.
So the file has not been produced before the court.
No, till today not file.
Mr. Das, where is the
And
file?
the minister has given note in the file. It is not anybody else. My IA para 16, page 16, please, Lordship may come. We have specifically said.
No, whoever may appear, that is a different matter, but there is direction of this court. No, the matter is a production of the relevant file before this court. You can produce it.
As per my instruction, for e-file, the votes taken by the
No, e-file, that's all right, but you can obtain printout. You obtain the printout and produce it before the court. We will list the matter tomorrow then.
Yes,
You
next
produce the
day,
file.
Lordship, someone, a Kapoti has appeared and the same stain was taken. Oh, that day I was not there. So next day I will bring it. So next day, Mr. A Kakoti appeared and he said, I will produce the record. That is on 26/11/25. Now today someone else has appeared. So that is why, that is how
So,
the things
on
are going
what
on
ground?
a public
No,
institution.
Mr. Sharma, on what ground the
Lordship, tomorrow, Lordship, let him bring it file, Lordship. I'll show from the record. And it's a black and white case, Lordship, we cannot continue. I'll show from the
no,
document.
no, on what ground he has been removed from the chairmanship?
Page 16,
That
para
has,
16.
pardon?
Page 16, para 16.
That is only your statement, no document is produced before
That
that.
is on record. We have said that it is on record.
Okay, then
And
let
that
it,
is why the court called for the record.
let him produce the record tomorrow at 2 p.m.
Lordship. Lordship.
Heard, Mr. S. Sharma, learned senior counsel assisted by Mr. Learned counsel for the applicant. Mr. P. Mohanto, learned counsel for the opposite party number
1 minute.
1. And Mr. S. Das, learned counsel. Learned standing counsel for the higher education department. You for UGC, Miss Learned counsel appearing on behalf of Mr. A. Somo, learned standing counsel for UGC, and Mr. T.K. Bhuya, learned counsel for the respondent number, opposite party number 6. During the course of hearing, Mr. Sharma, learned counsel for the petitioner, has pointed out that by order dated 10/11/2025, the standing counsel for the respondent in higher education department was directed to produce a relevant file before this court. But the same has not been produced before the court till date. Accordingly, Mr. Das is directed to produce the relevant file before this court by 2 p.m. tomorrow. List the matter accordingly at 2 p.m. tomorrow.
Can you be day after tomorrow? Sir?
No.
No.
No,
Tomorrow, Lordship, things are going on like this, Lord.
these are documents, Mr. Sharma, you can take back
Yes.
this document, you can produce at the time of hearing.
Yes, sir. I'll take it. I'll take it. There is some more document. Lordship.
Item 53.
Okay, you can take.
Like, give it.
Can it be taken up to something? Council say, affordable could appear on for other party number 1.
Oh,
Yes, water good.
pardon?
Yes, water good.
Or Thakur. Okay, wait for some time.
Pending item number 6.
May I please, your worship? Lordship, they have filed the affidavit, the lordship may take up on Wednesday.
They want it to be on Wednesday, well, they will file the reply. Affidavit, file.
Okay,
Lordship,
Pardon
we
me?
don't need to file, not required for reply. But my senior, he have some urgency and left, so lordship may take up on Wednesday.
okay, all right. Learned, your name please.
HK Suni.
Learned counsel for the petitioner, and Mr. B. Gogoi. Learned standing counsel for the respondent in health department. The learned counsel for the petitioner submits that the respondent herein have filed their affidavit in opposition, and the petitioner will file reply to the same and price for granting some time, pair allowed, rest is the matter.
Lordship, we
vacation?
won't file the reply. We won't file the reply.
Pardon?
You won't file the reply, lordship. We'll
You will not file.
Yes, sir.
Okay, would not file a reply. In that view of the matter, SSL lays the matter after vacation for admission hearing.
Lordship, on Wednesday,
They want it to
17,
be on Wednesday.
there's an urgency.
Yeah,
Day after tomorrow, lordship.
easy admission is there.
Easy admission. Okay, then day after tomorrow.
Oh, bless lordship.
Pending item number 31 and 32.
But this is for non-compliance. This is a case of 2020. They are thinking about the matter in 2025, they have filed an appeal. That appeal was also dismissed. Still they are sitting over the matter, my lord. Even, my lord, during the proceeding, my lord, one of the person has already died. I have substituted him. And others is going to be retired.
After the dismissal of the appeal, the steps has been taken towards compliance. The report and the proposal has been called from the inspector of schools for adjustment and creation of supernumerary post. So would require 15 days time to process the proposal.
Complete the process. Whether you will be able to complete
Not,
it within 10
not
days.
complete, to proceed with the, to process the proposal. Because after the proposal is, it comes from the inspector to director and director to secretary. Then secretary will send it to the finance department. So
Even, my lord, it has reflected earlier, they have several times the proposal has been submitted. That was returned back, and then with a direction by the finance department that.
sending a correct proposal, we have asked the inspector of school. Inspector of school has requested for 15 days time to.
That was given long back.
Heard me, sir?
Immediately after the review vacation, we can update the process. In the meantime,
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. B. Kosek, learned counsel for the contender number 11. M410, Finance Department,
finance.
Mr. Soliha for respondent number 10. During the course of deliberation, Mr. Kosik has produced one letter of the Director of Secondary Education dated 12/12/2025. And on the basis of the said letter, Mr. Kosik submits that the director has already requested the inspector of schools to send correct proposal, and on such proposal being received by the Director of Secondary Education, the same will be processed and will be sent to the Finance Department for sanction, not for approval. And as such, he prays for listing the matter after 15 days, so as to enable him up to date status of the said proposal. Where allowed, recess shall list the matter on 20 January. The letter produced before the court today shall be marked as Annexure X and be tagged with the record. What for some time?
Yes, yes.
Number 35.
Much ado.
Hello, though I am a party here, Madam. The Dimahasa Autonomous Council is the main party, Madam, because these are transfer subjects. I am for the state PhD, and the order impugned is passed by the finance department. That or regulation was cancelled by finance.
No, who passed the order?
The order-
Cancellation order was
impugned
passed by whom?
finance department. And it
No,
was
whether Finance Department is the appointing authority. Whether Finance Department is the appointing authority.
Yes, sir. Finance has to. Different order.
Respondent number 2. My lord, respondent number
Respondent
2.
number 2.
My lord,
Have you filed your affidavit here?
my lord, only one submission, my lord, I have. My lord, at page 54, my lord, if your lordship see the page 54, my lord, the regulation order, my lord, at page 54, my lord, page 54 of my additional affidavit, my lord. My lord, my lord, serial number 11 is Babulal Burman, my husband, and serial number 12 is one Haya Nampu, and serial number 22 is Sri Bipin Hapila. I have placed the 2 order of Bipin Hapila and Haya Nampu. Similar case, my lord. In their case also, the regulation was cancelled, my lord. Ditto case.
Mr. Gogoi, you see, he has produced 2 orders or 2 repetitions.
The same, ekdam same order.
Where the other 2 persons service of other two persons were regularized as per order of this court. His fear is that similar order may be passed. Now, the question is, do you have any objection in passing similar order? No, objection from the finance department is not required. What is required is whether the present petitioner is similarly situated with the petitioners of this writ petition or not. Wednesday. Furnish a copy of these two judgment to him. Heard Mr. N. Sorkar, learned counsel for the petitioner, Mr. D. Gogoi, learned standing counsel for the PAC department, Mr. B. Sharma, learned standing counsel for the accountant general, and Mr. B. Gogoi, learned standing counsel for the finance department. During the course of hearing, Mr. Sorkar has produced two orders passed by a coordinate bench of this court in WPC number 1231 of 2022 and 5053 of 2024, wherein direction has already been issued to regularize the service of the petitioners of those writ petition. And he also submits that the present petitioner is also similarly situated with the two petitioners in WPC number 1231 of 2022 and WPC number 5053 of 2024. And as such, he has contended to pass similar order, granting similar relief to the present petitioners, like the petitioners in those two writ petition. Mr. Gogoi, learned counsel for the finance department, submits that he may be granted some time to go through the writ petition, order of the writ petition number 1231 of 2022 and WPC number 5053 of 2024. Accordingly, it is provided that Mr. Sorkar shall furnish the copies of order dated so and so passed by this court in WPC number so and so to Mr. Gogoi during the course of the day. Justice shall list the matter on Wednesday.
I have already furnished the copies, madam. Obliged.
Item 38.
May it please your lordship. Lordship, service is still awaited in this matter. And however, we have served the dusty copy. We have filed an affidavit. It is not on record, lordship.
Oh? Oh, respondent number?
Sole respondent.
Sole respondent. Okay. Heard, Miss?
And Begum.
Learned counsel for the petitioner and Mr. E.K. Bora, learned counsel for the contender. Mr. Bora submits that he has filed his Ukalat number today and press for listing the matter after vacation, so as to enable him to obtain instruction from the respondent contender in respect of the compliance of the order dated 15/12/2023 passed in WPC number 6585 of 2030. We are allowed to list the matter on 22nd January. 22nd January.
Much obliged.
39.
May it please your lordships, from office note, I have seen that service is awaited. May I take my lord justice service in this case?
Part Ms. K. Devi, learned counsel for the petitioner. Ms. Devi submits that service report upon the respondent is still awaited.
Only
And
one
she
respondent.
tries for granting her permission to effect service upon the respondent by Dastimut. They are allowed. After effecting service upon the respondent contender by Dastimut, the petitioner shall file an affidavit before this court. Justice shall list the matter After 2 weeks? After 2 weeks.
Highly obliged.
Item 40.
May it please your lordship.
Yes.
Lordship, as the office note dated 10/12/2025, service report is awaited for response number 1, 2, and 4.
In respect of 3?
In 3, lordship, as per office note dated 10/11/2025, acknowledgement card has returned, but lordship, no one has appeared, lordship, for
Okay.
3.
So you want to take fresh step upon respondent number 1, 2, and 4?
Lordship, I'll take fresh steps, lordship.
Okay. Part Ms. P. Borwa, Learned Counsel for the petitioner. Office note dated 10/12/2025 indicates that neither ID card nor unserved notice issued to the respondent number 1, 2, and 4 returned to the section. The Learned Counsel for the petitioner submits that she may be permitted to take fresh step upon the respondent number 1, 2, and 4. Where allowed, registrar list the matter after 4 weeks. Step be taken upon the respondent number 1, 2, and 4 by registered post or stroke speed post, and also by usual process within a week from today.
Deeply obliged.
Item 41.
May I please, your lordship. This is I, lordship, for prayer is lordship for amending the writ petition, lordship, some typographical error, lordship. I have mentioned in para 2 from para 2 lordship. 12.
So there are many errors.
Lordship. Some
Better you withdraw this petition, file a fresh one, will grant you liberty.
lordship. Lordship. Lordship may pass. Lordship may pass, lordship.
Okay. Heard Mr. Bhattacharya,
Lordship.
Learned Counsel for the petitioner. And for the respondent, Mr. Gogoi for, no, Mr. Pego for respondent number 1 and 5. And for respondent number 4. Borwa for respondent number 4. And Madam? 3. The Learned Counsel for the petitioner submits that while preparing the writ petition, being WPC number 6606 of 2025, some errors crept in inadvertently, and as such, an interlocutory application has been filed for according permission to amend the writ petition. However, during the course of hearing, Learned Counsel for the petitioner submits that he may be allowed to withdraw this WPC number 6606 of 2025 and the IA number 3953 of 2025 with a liberty to approach this court again by filing appropriate petitions. Accordingly, taking note of the submission of Learned Counsel for the petitioner, this WPC number so and so and the IA number so and so stands disposed of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
That's obliged.
Item 42.
You, Mr. Bhattacharya, do you want to take back some of the documents enclosed with the petition?
No, Lordship,
Not
have
required.
already, all documents I have annexed, Lordship.
No, no,
Some,
you want to take back those documents?
Lordship may take. I may
Okay.
also take.
Mr. Bhattacharya also submits that the documents filed by him in the WPC number so and so may be allowed to take back from the registry. They are allowed. Registry shall return the documents to Mr. Bhattacharya.
Obliged.
42.
May I please, Lord? Let kindly see the last order, my lord.
Yes, Mr. Dotto, what is the
Yes, it
status
was
of the
mis-
letter?
Yes, it was mistakenly sent to Treasury Officer Dhuburi Lotip instead of Goalpara. So we have written to the.
Instead of correct address is Dhubri,
Yes.
but it was sent to
It should
Goalpara.
Goalpara.
Yes.
We have written to Goalpara Treasury Officer to return it for your honor submission to Treasury Officer Dhuburi Lotip. That communication I have. It was mistaken from our part.
Yes. Lordship, it was not Goalpara, it was Dhubri also, Lordship. There's no school in Goalpara with that name, Lordship. I sought my clarification from the, it has to be sent to the Dhubri treasury also, Lordship.
Now what to be done?
Lordship, we have already written to the department, Lordship, they are supposed to send that same communication to Dhubri treasury office. Whether they have. Well, Lordship, then I'll just obtain my instruction from the Dhubri treasury officer. This was.
You have sent it to the Dhuburi?
And we have, yes, we have sent a letter to Dhuburi on the 9th of 12/2025.
9/12/2025.
So
Okay.
after reopening, Lordship may fix, we will get the up to the discussion.
On Friday?
Yes, my lord.
I can get an update from the
Yes,
treasury about.
yes. Heard Mr. Hussain, learned counsel for the petitioner. Mr. Dotto, learned counsel for the respondent number 1, 2, and 3. Mr. Medhi for respondent number 5, Mr. Solia for respondent number 6. Mr. Dotto, on instruction, submits that mistakenly the letter was sent to the Treasury Officer Goalpara Treasury instead of Dhuburi Treasury, and that on 9/12/2025, the department has already written a letter to the Treasury Officer of Dhuburi, for disbursing the amount. For disbursing the amount which the petitioner is entitled to.
I want to receive, my lord, 4,37,829.
Accordingly, Mr. Soliha, learned standing counsel for the finance department, is directed to obtain instruction regarding the status from the Treasury Officer Dhuburi. Mr. Dotto shall furnish a copy of the letter written by the department to the Treasury Officer Dhuburi to Mr. Soliha during the course of the day, so as to enable him to obtain instruction. They are allowed to recess list the matter on Friday.
Lordship, here the communication, here they have only asked us to return the original advice slip and non-drawl certificate. It is not regarding making payment, Lordship. So,
Okay.
So.
Correct.
So.
Regarding returning the
Request you to kindly return the original advice slip and non-drawl.
original advice slip with non-dual certificate.
certificate.
Okay, then again they have to write to the Dhuburi Treasury.
That they have written, Lordship. So I'll just obtain the instruction regarding whether or not.
They have received it and make
and
payment or not.
these details have been forwarded.
Okay. Yes, noted.
Supplementary list, section number 54.
Recorded.
Obliged, my lord.
Made easier lordship. Lordship, nothing further. Lordship, rely on the IA. Submission for the IA has made before this court.
Mr. Tobilder, you have received the copy of the IA? So any objection? No. Heard, miss?
B person.
Learned counsel for the applicant. This application under Order 6, Rule 17 of the Code of Civil Procedure is preferred by the applicant seeking amendment of the writ petition, being WPC number 662 of 2025. The learned counsel for the applicant submits that in the pair portion of the writ petition, being WPC number 662 of 2025, some inadvertent error has been kept in and as such the same is required to be corrected as under page number 8, the second paragraph. Mr. Tobilder, learned standing counsel for the respondent in higher education department, submits that he has no objection in the event of allowing this interlocutory application. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The pair portion in the WPC number so and so shall be amended as under. And in view of the order being passed in this IA, the council, the petitioner in WPC number 6662 of 2025 shall file amended cause title within a period of 1 week from today. Yes, shall list the matter after 1 week. In terms of this, IA stands closed.
Timing at number 53.
Okay, and also furnish copy of cause title to the learned standing counsel for the opposite parties. For the respondent in writ petition numbers and so. Yes.
My lord, this is an application under Article 226(3), my lord, for vacation of the interim order passed in this writ petition, whereby, my lord, the parties were directed to maintain status quo. The petitioner before lordship was transferred from Dhubri to Goalpara. Considering his, my lord, health condition and his father's health condition, my lord, the authority, he applied before the authority. Authority considered his application and he was transferred from Dhubri to Goalpara. And the respondent, writ petitioner, he was transferred from Goalpara to Dhubri. But he has challenged the transfer order. But he is a resident of Kamrup district, and there is a post lying vacant in Kamrup also. He could have applied for his modification of the transfer order, for enabling the authority to transfer him to Kamrup district. And in such situation, my lord, the Honorable Apex Court also, my lord, in time and again held that, my lord, the parties who, instead of, my lord, challenging the transfer order, they should report the transferred place and approach the authority for modification if any grievance is there.
No, the person who filed the writ petition, he belongs to Kamrup district.
Yes, my lord.
And some posts are lying vacant in
Yes, my
Kamrup
lord.
district.
Yes, my lord. In Kamrup rural, my lord, there is a post lying vacant.
Okay.
Ultimately, it has to be decided by the respondent authority, the government.
Let my friend apply before the authority, my lord, for modification of his transfer, my lord, if he has any grievance.
If I may. Lordship, I was transferred to Goalpara. On Lordship,
23/9/2024. After just 1 year of service, I was again transferred to Dhubri. I was transferred to Goalpara in his place, and he was transferred to Dhubri, Lordship. After just 1 year of service, Lordship, and he has applied to be transferred back to Goalpara. And Lordship, in our writ petition, para 7, we have categorically mentioned that he has served for almost 10 years in Goalpara before his transfer to Dhubri, Lordship. And he has not denied that, Lordship. Neither in his interlocutory application nor in the reply he has filed, Your Lordship. He was placed in Goalpara for almost 10 years. Then he was transferred to Dhubri. And in his place in Goalpara, I was transferred.
No, the transfer was made on his request?
Yes, my lord. On my request, my lord.
Okay.
So 10 years he has served in Goalpara. Then he was transferred to Dhubri. And I was transferred to his place in Goalpara. After just 1 year, he has again requested that I need to be sent back to Goalpara in my place, where I have just settled down. I was conducting my day. I've been doing my duty, Lordship, without any blemish, Your Lordship, performing. Just 1 year of service now, and he says that he wants to come back to Goalpara, Your Lordship. That's the main issue, Your Lordship. The court has
No,
also.
if you are belonging to Kamrup district, you can come to Kamrup district
That I can understand, but that ultimately has to be decided by the
authority.
government, Lordship. And that is why I'm praying that Lordship may take it up tomorrow, and Lordship may see what Mr. Council S. Borthakur has to say. Maybe he will argue this matter.
Oh,
Council S. Borthakur, Lordship. And I don't have any specific instruction from my client as we got to the Kamrup.
Mr. Gogoi, you are for?
For the service Abhidan when issued a transfer.
Okay.
Kamrup part is not there in the order, my lord. The private respondent, he cannot take the plea that there is some vacancies in Kamrup, someone should be transferred here. He is to defend this order. Either he, my lord, is successful or my lord, it goes against him. He cannot make those assumptions. Here, my lord, is a case, my lord, where in 2024, the petitioner was transferred from Goalpara to Dhubri. Now, my lord, after 1 year this year, my lord, in October, he has been again transferred back to his earlier post. The agreed by that is before the honorable court. My humble submission will be, my lord, transfer is an incidence of service. It is always associated with my lord, service. Now, there is no such policy of the service Abhijan. Or at least, my lord, in the petition, nothing has been shown. That one cannot be transferred within period of 1 year of his earlier transfer. And my lord, so far as the FRSR is concerned, of the my lord, service Abhijan.
No, Mr. Gogoi, what is there in the rule, it is there.
Yeah.
But if they want to, if the applicant in IA, he wants to come to this Kamrup district, can it be accommodated?
He Kamrup.
Well, no, he's saying that the petitioner should go to Kamrup. So that he remains in
Goalpara.
That's why I'm saying he cannot point out who will go to who. He will have to defend
I am
those
just saying that a post is lying vacant in Kamrup also, and he is a resident of Kamrup. That is what I am saying, my lord. I am not saying that he should be directed to be transferred to Kamrup. I am not saying that, my lord. He can approach the authority as I have approached my difficulty. I am by showing my difficulty, my lord, I approach the authority. The authority has considered my difficulties, and I have been accommodated. I have been accommodated. My son is also appearing in the class 10 examination, my lord. I am also suffering from, my lord, various ailments. My wife is also, my lord, diabetic patient, my lord. Considering all aspects, my lord, I was transferred.
Public interest has to be looked into.
And, my lord,
There's no public interest involved there.
in the
There, Lordship.
appointment
It's only private
contract, my
interest.
lord, and in terms of the appointment contract, my
Okay,
lord, clause 8,
Mr. Soikia,
my lord,
today Mr. Borthakur is not present. Let it be tomorrow then.
day after tomorrow, my lord.
Day after tomorrow.
Or Thursday maybe.
Thursday question.
Let it be on Thursday, madam. I will try to have the record, whereby my lord, the application of the private respondent means Mr. Sekia's client. That was processed and whatever justification is there for modifying the transfer order, I will place it before the honorable court.
Okay. As agreed by learned advocates of both the parties, recess shall list the matter on Thursday. On that day, Mr. Gogoi shall produce the 11 record before this court
Relating to the transfer.
relating to the
At 2 p.m., my
transfer.
lord. At 2 p.m., my lord.
Okay, at 2 p.m.
My lord.
Are you saying?